morning.
Good morning.
Are we ready?
Stage ready, Your Honor. Ready, Your Honor. Yes, sir.
Okay, you may bring the jury. I think it's amazing we have everyone here, but you're all probably some early birds in this part of the state.
We were admonished. We didn't want to find out if we weren't.
Everyone's here. Good morning. Welcome back. Day number 3. State's case. Next witness.
The state calls Jimmy Garvin.
My name.
Is that all night? Sometimes we have them, they're not all.
Is that better? Is that better? Better? Yes.
Yeah, thank you.
My name is Demetra, Demetra, Garvin, Gar, V as in Victor, IN as in Nick, and I'm commonly known as Dr. Demi Garvin.
Dr. Garvin, what do you do, ma'am?
I'm currently the Director of Forensic Sciences for Forensic Science Network, which is a privately held company that provides drug testing, forensic testing services, support services, as well as training, quality assurance audits for coroners, pathologists, law enforcement community, attorneys, and healthcare providers.
As a doctor, what are you a doctor in exactly?
I have a Bachelor of Science degree from Furman University in biology, and I have a doctorate in clinical pharmacy from the University of South Carolina College of Pharmacy in Columbia.
How long have you, and as a doctor now, what toxicology, how long have you been doing this in particular?
So I was for 16 years a staff toxicologist and training coordinator at the State Law Enforcement Division, better known as SLED, in Columbia. In 2000, after 16 years at SLED, I went over to the Richland County Sheriff's Department in Columbia and helped Sheriff Lott establish a full-service forensic laboratory with multiple disciplines, crime scene latent prints, DNA, firearms, evidence of property, drug chemistry. I think I have named them all. And was there as the laboratory director for 15 years. Subsequent to that, in 2016, I retired from government service and went full force into the consulting and training.
And that's been how long have you been doing that?
Oh, almost 20 years, actually.
I'm trying to calculate. How many years is that in the field of toxicology?
Toxicology and drug chemistry, this will be my 38th year.
And have you been qualified in court before? And I guess the expertise would be toxicology and chemical. What you said it better than I did.
There are actually 3 areas: forensic toxicology. I'm a board-certified forensic toxicologist. Drug chemistry, forensic drug chemistry, which is the analysis of what we refer to as pills, powders, potions, paraphernalia, and plant material, the 5 Ps. And I'm also a registered pharmacist here in the state of South Carolina.
And as an expert, you've testified in pretty much all those fields?
Yes, sir.
And how many times have you been qualified in courts in South Carolina as an expert?
Been qualified in South Carolina and beyond over 250 times, all court settings excepting international.
So from the standpoint of an expertise, your expertise in toxicology and forensic chemistry?
Drug chemistry, yes, sir.
Drug chemistry. Your Honor, this time we offer Dr. Demi Garvin as an expert in those fields.
Says the defense.
He's an expert, Your Honor.
No objection to qualification, renew objections regarding his testimony.
She is so qualified.
All right, now, Dr. Garvin, as an expert, I know you have reviewed the entire file. At one time, you actually started a while ago on the decedent, Cristina Pangalangan. Is that correct? You actually did some work on her originally?
Yes, sir. As part of the Forensic Science Network, myself specifically, we provide consultative support, toxicology and drug chemistry support to the Colleton County Coroner's Office. And in this particular case, the coroner engaged with me to assist him in helping the Medical University of South Carolina pathologist of record to identify the proper testing, toxicology testing on the specimens collected from autopsy to ensure that comprehensive testing was performed under the circumstances of the case as they were known at that time, and then to provide a narrative summary of the results when the analysis was completed.
Have you reviewed all of the test results in this case, including the test results from Rita Pangalangan as well as Larry King?
Yes, sir.
All right, let me start first with, and we had testimony of this yesterday, but I want to make sure I get the number right. First of all, let's start with Rita Pangalangan. What were the results of her toxicology screen?
I'm
Yes, sir. Proceed.
Go ahead, I'm sorry.
So I'll provide the pertinent positives. The blood sample collected from Ms. Pangalangan, I believe, was positive for methamphetamine.
All right, I'm just going to put meth because I'm not sure I can get the full spelling on that.
At a concentration of 400 nanograms per milliliter, with a corresponding amphetamine concentration of 160 nanograms per mil.
All right, now, I do not know what nanograms per milliliter mean. So can you kind of tell me what that means or any significance to that?
So generally speaking, when we're dealing with drug concentrations in a biological sample, in this case a blood sample, there's a unit of measure associated with that drug. And that can vary broadly depending on the drug in question. So if you think about when your height or your weight is obtained, we don't just put 150. There has to be some unit of measure after that to put it into context, 150 pounds, 150 ounces, whatever that might be. The same with our height. The same is true with a drug concentration. So nanograms per mil in this instance is a measure of this particular drug, how it would be reported on the toxicology report, nanograms per milliliter. So it's a unit of measure.
And you brought something up that I want to ask you about. You said ways of testing, and I think you made some kind of reference to blood tests. There are other ways of testing for method assisted versus urine tests. Is that correct?
Yes, we can test for methamphetamine and its corresponding active breakdown product, which is the amphetamine that you see there. We can test for it in blood. We can test for it in urine, oral fluid, formerly known as saliva, tissue specimens, ocular fluid, any number of biological specimens.
What's the advantage of a blood test over, say, a urine test?
So, particularly in a living person, the blood test is a very good selection in terms of the specimen because it represents what is happening in real time, if you will, in association with that sample.
Let me go ahead and get down Larry King's results as well, if you could go to that, please.
Yes, sir. Again, the pertinent positives are methamphetamine at a concentration of 480 nanograms per milliliter, with a corresponding amphetamine concentration of 88 nanograms per milliliter.
Okay, and again, that was a blood test as well, is that correct?
Yes, sir.
Now, Dr. Harvey, what can you tell me from the standpoint of 400 nanograms or 480 nanograms per milliliter as to the influences that drug would have on a body?
So, first of all, just to contextualize the drug itself, methamphetamine is a very potent man-made central nervous system stimulant. So when we talk about stimulants, we're talking about a compound that increases our heart rate, our respiration, our temperature, our, up to a certain point, potential cognitive ability, and other physiological and psychological functions. With increasing doses, the drug becomes those doses that are associated with misuse, abuse, and then above that towards toxicity and lethality. We see the potential for a cardiac event, sudden cardiac death, or central nervous system activity to the point of seizures and death potentially from that. The drug is used medicinally, so there are prescriptive reasons to be using methamphetamine. In this country, in the United States, specifically attention deficit hyperactivity disorder, otherwise known as ADHD. It has been used for weight loss, although that tends to be less so now because they're safer drugs for that purpose. And it's also used for a condition known as narcolepsy, which is essentially a condition in which the patient has difficulty staying awake and will actually spontaneously fall asleep with no warning. So it can be used for its stimulant effects in those instances medicinally.
All right, so let me back you up on this. You had three different levels. You had the first level, then you had the misuse level, and you had then the third, which was the potentially fatal level. Is that correct? And I don't remember what you called the first level.
Therapeutic. Yes, because the drug is available medicinally.
Okay, so the first thing you're talking, okay. Therapeutic, and then misuse, I think is what you used?
Yes, or misuse, abuse.
And then it's fatal.
Potential fatality, yes, sir.
All right, from the standpoint of those three levels of the use of this drug, you're talking about it from the standpoint of using it on a doctor's prescription, that type of thing. Are there certain levels at some point that you start looking at this to say, this level in the bloodstream would fall under this category and things like that?
Yes, there are benchmarks, if you will, or bright lines where we can put into context what we, in our opinion, based on education, training, experience, and the peer-reviewed literature, associate with those three different situations. So typically with therapeutic use of methamphetamine, We're expecting to see concentrations, again, and my comments are relegated completely to living individuals, not someone who is deceased. So in a living individual who's receiving the drug by prescription, legitimately, we are expecting to see concentrations around 50 nanograms per mil and less. So somewhere between 10 nanograms per mil and 50 nanograms per mil, typically. We might. Nanograms per milliliter, yes, sir. There might be, and there are going to be a few exceptions to that, depending on how the patient was dosed and what the condition is and their body habitus. But 50 nanograms, might even see some cases that approach 100 nanograms per mil, but generally less than that.
Okay.
Yes, sir.
All right. Then, what gets us into that second category?
So, misuse, abuse of the drug, typically anything above 200 nanograms per mil is associated with misuse or abuse.
So I'm assuming that somebody even that's prescribed methamphetamine, they get it past 200, they're not doing it on the doctor's instructions, they're doing it on their own.
That's been my experience, yes, sir.
Okay. So that's anything north of 200 nanograms, is that correct?
Yes, sir.
When do we get into the fatal end of it?
So this is where overlap occurs. So above 200 nanograms per mil, when we say that we're in the misuse abuse range, we also begin to see, that doesn't mean that someone could not die from abuse of the drug. 300, 400, 600 nanograms per mil, upwards of 1,000, 2,000 nanograms per mil. We begin to get into dangerously high area for the potential for overdose. To put that into further context, I have cases personally that I've signed out with individuals who have died after having achieved 20,000 nanograms per mil. So there's a huge range. Even north of that, I think my personal experience has been a case where an individual succumbed at 38,000 nanograms per mil.
But the low end of that is, you've seen it at what, 300?
300 nanograms per mil, 400 nanograms per mil, 600 nanograms per mil.
By the way, just on an aside, is there a statewide prescription reporting system that you also have access to?
That's known as the Prescription Drug Monitoring Program here in South Carolina. It's a database for healthcare providers to access and enter information about a patient when they're receiving controlled substances. So the prescriber has access to that database, the pharmacist has access. In the state of South Carolina, because I don't have an active patient-provider, even though I am a pharmacist, because I don't have an active patient-provider relationship, that information is made known to me from an individual who does. So I personally did not access that report, but the information therein was provided to me.
But that information is stuff that you normally would use in your role as a toxicologist in making everything from expert determinations to analysis and things like that. Right?
Yes, it certainly could be, yes.
Do you have any information concerning either Larry King or Rita Pangalangan in accordance with that?
Yes, sir.
Okay, what is that information?
So based on the information that was provided to me about the prescription drug monitoring report, there was no evidence that either individual had been prescribed a compound that was methamphetamine based.
And if they
Or,
were
pardon me.
nanograms per milliliter, that's much higher than the doctor would prescribe anyway. Is that correct?
Well, it's not a concentration. The concentration doesn't reflect prescribing, but neither one of those individuals had prescriptions for either a methamphetamine-based compound or an amphetamine-based compound.
So now you brought up another point on this then. From the 400 nanograms per milliliter, can you tell me, I guess from the standpoint of that doesn't necessarily mean they took a certain amount. They could have taken a lot to build up to that. How does that work exactly in a bloodstream?
So the concentrations that you see depicted here are a function of a number of factors. Certainly the drug that's administered. the dose, which we don't know, the time of the dose, which we don't know, then whether or not it's a single dose or whether it's multiple doses, the individual's ability to metabolize or break down the drug, in this case from methamphetamine, which is the parent drug, to amphetamine, which is the metabolite, which is also active, which is the active form of the drug. This is our body's, the way that our body removes the parent drug and prepares it for elimination from the body.
At 400 or 480 nanograms, that fall into the misuse category, can you tell if those results, somebody with that in their bloodstream, which you testified is actually a very good way of testing, are they under the influence of meth?
So with methamphetamine, one can be actively under the influence. So what do we mean by that? Well, because it's a stimulant, we tend to see certain side effects or adverse effects when the drug is misused associated with it. First of all, the individual is misusing the drug to achieve a sense of euphoria and well-being. And that is created initially by its effect on neurotransmitters in our brain, certain neurotransmitters in our brain. So the individual wants to use the drug to achieve this sense of well-being, this sense of euphoria. They also are on the receiving end of the changes in blood pressure that I mentioned earlier, potentially changes in temperature, potential changes in heart rate, breathing. They become more excitable. They become more stimulated. That could be stimulated in terms of their motor function. It could be stimulated in terms of their sexual function. They may become more hypervigilant, which means they might be staying on a task more specifically, or obsessing about something in particular, a particular situation. They then, again, with increasing doses, that can proceed to more pronounced adverse effects, which could lead to cardiovascular collapse or to seizures in worst case scenario. Then there's a backside of the drug, which is when the individual is coming down from the drug. So there are effects when the blood concentration is rising and the individual is actively under the influence, and then there are also effects when the individual is coming down or is away from the drug, if you will. And that, if you think about it, it's sort of intuitive that those effects are kind of the opposite. So the person becomes fatigued. They may become depressed. They're looking for their next dose potentially because they want to feel good again. All right, based on the neurotransmitter release. So opposite effects. Typically, they may crash. That's actually referred to as crash, where they sleep, where they may have been up for days or hours during active use. Now, coming down off the drug, they may sleep for days, hours or days.
So the influence is actually going to be spanned over not just when they're taking it, but also after they take it.
Yes,
not
correct.
Just right immediately afterwards, but for a while.
Yeah, the entire continuum of their relationship with that drug. Yes, sir.
At 400 nanograms per milliliter, at 480 nanograms per milliliter, what would you expect to see as the side effects of that, or the effects of that on somebody?
Well, it's difficult to say. It could be either situation. It could be the individual, because we don't know the time of last dose. It could be the individual actively under the influence, so they're stimulated, they're hypervigilant. Again, some of those effects that I mentioned earlier, increased libido, obsession, euphoria. They may feel excessive strength in some instances, risk-taking behavior. And then if they're coming down, which that concentration could also reflect, they're exhausted, they're sleeping, fatigued, irritable. So methamphetamine does affect our cognitive ability in misused, well, let me start with therapeutic doses. So one of the reasons that it's given for ADHD, attention hyperactivity disorder, is because in certain populations who have been diagnosed with that condition, the drug helps that individual to stay on task, to stay on focus. But the drug dosing associated with that condition is low. 2.5 milligrams, 5 milligrams, 10 milligrams, perhaps up to 30 milligrams a day, depending on whether we're treating an adult or a child, a young person. Misuse, we're talking about doses of up to 1,000 milligrams a day. So much, much higher doses of the drug. And with binging, which is repeated dosing, multiple times over a short period of time or over several days perhaps, individuals have been documented to self-administer up to 5,000 milligrams a day. So very, very large doses of the drug.
And at that level, what would you expect to see them as far as their cognitive ability?
So our cognitive function consists of our ability to reason, to make good decisions, decision making.
I think the question is unclear.
Well, just a moment. Your objection is the question is unclear?
Yes, sir.
All right.
The answer is vague. I mean, she's
Well, just a moment.
up to 5,000 milligrams.
Give me a legal basis for your objection only.
There's not a foundation for this testimony.
Let's listen.
She's an expert in this field, and I've asked her a clear enough question that she is having no trouble answering it.
There's no testimony before the court of anybody having up to 5,000 milligrams, etc. If you restrict it to the 400 or 410, I think the question is proven.
Objection's overruled.
Go ahead, I'm sorry. Go ahead.
Could you ask the question again? I'm sorry.
I don't know if I can remember it. At the levels of 400 and 480 nanograms, and in the misuse category, which is you've got as basically 200 plus is in the misuse category. So let's talk about the misuse category. What would you expect the people to act like in that category over 200 from the standpoint of cognitive skills, motor skills, libido, that type of thing?
So it's difficult to ascribe specific effects with a specific concentration. We can talk in general terms based on what we know with regard to the published literature. And without knowing whether the individual is actually actively under the influence here or coming down off the drug, being separated from the drug prior to perhaps the next dose, there could be effects on cognitive function of decreased judgment, decreased critical thinking skills, decision making. Those would be effects that we would see.
Say that again, I'm sorry.
So decision making, judgment, critical thinking. Part of critical thinking would be lessened ability to recognize the consequences of our actions.
Can you also say libido?
Well, that's not cognitive ability.
Okay, I'm sorry.
Right.
That's not cognitive. Okay, that's just cognitive.
It's,
Okay, what else?
I think
Other than cognitive, what else are we dealing with?
actively under the influence, euphoria early on, stimulation, perhaps feeling of increased strength,
Okay.
possible increased libido.
And that's basically sex drive, is that right?
Yes, sir.
You know, you're using the term influence. Obviously, I know what you mean when you're saying the actively using it as opposed to still being there. But if you have 400 nanograms per milliliter in your blood, or 480 nanograms per milliliter in your blood, is that affecting the person that has it in the blood at that time? You mentioned earlier contemporaneous and that type of thing. Can that tell us anything?
It would be my opinion that it would be impairing the individual. Yes, either by virtue of being actively under the influence of the drug as a central nervous system stimulant, as I've described here, or on the backside coming down off the drug. That's commonly referred to as tweaking, and where the person's it's been some period of time since their last dose, and they're either actively seeking another dose or have been removed from the ability to obtain another dose.
Either way, it's affecting them right away.
Yes, sir.
I don't have any further questions at this time, Aaron. Thank you.
Mr. Lawyer?
Thank you, John.
Yes, sir.
Good morning.
Good morning.
And I'm sorry, I was listening, but I didn't catch your name. Did you ask me?
Demi Garvin. Garvin, G-A-R-V-I-N.
Go with Doctor. Doctor, first, I know that the solicitor was taking care to know your comments and your answers. And I understood your therapeutic zone could be 10 to 50 or even as high as 100. Is that right?
Yes, sir.
I see you didn't put that up there, but 100 would still be within the therapeutic range. Is that correct?
We see some individuals, yes, it's typically less than 100 nanograms per mil for therapeutic dosing.
With, and I was listening to your credentials also, it sounds like you can testify to us about all sorts of substances, with expertise in all sorts of substances. I assume that would include alcohol also, is that correct?
Yes, sir.
Is there a tolerance with certain substances within your field? Is that a term you all use, tolerance, substance or drug tolerance?
There is such a thing as tolerance, yes, in association with alcohol and other drugs. Yes, sir.
Explain to the ladies and gentlemen of the jury what that means.
So, well, there are different types of tolerance, but the tolerance that people are most commonly aware of is the condition where repeated dosing of a particular drug, to include alcohol, but methamphetamine is another compound where this could occur. The same dose given with repetition, that individual becomes less responsive to it, necessitating a higher dose the next time. Probably the most classic compound that that type of tolerance occurs with is alcohol, where one dose of alcohol, one alcoholic beverage, the individual starts to ingest that, and over time, if they continue to use alcohol, they need more of an alcoholic dose or more drinks to achieve the same effect that they're looking for.
So, a young person who's never, or even an adult person who's never consumed alcohol and drinks alcohol might become intoxicated at a very low level in their bloodstream. Is that correct?
Yes.
Whereas a person, if you will, I don't know what the better term is, a more experienced drinker might be able to consume several times that amount of alcohol and at least show very little effect. Is that correct also?
Yes, individuals who are chronic, with regard to alcohol, and individuals who are chronic alcohol users, they develop functioning at higher concentrations, so it's more difficult to ascertain their impairment. They're still impaired from ethanol, but it's more difficult to discern it without objective criteria to do that, particularly objective testing.
And the same applies to other substances too, does it not, generally speaking?
Correct.
And we talked about y'all talked about the ranges up to a deadly range. And I noticed that you said that you have seen, either personally or in the literature, blood alcohol levels up to 20,000 or 38,000 even nanograms per milliliter. Is that correct?
Not blood alcohol, methamphetamine concentrations.
I'm sorry, I was didn't make that clear. I'll put back the chart now. As far as methamphetamine goes, you said you have seen it up to that level in various individuals, either personally or in the literature. Is that correct?
Yes, sir.
And could we assume that, or would it be fair to say that those people must have been chronic users and built a tolerance to the substance, not to have died earlier in the range? If somebody who's never used methamphetamine is he more at risk at 1,000 milligrams or nanograms per milliliter than a person who has used it regularly?
There are a lot of variables that go into that. Broadly, yes. And just for the record, the individuals who were in the, I'm personally not familiar in my role with any individual who's come into my work practice environment for review who was alive above 3,000 nanograms per mil. All those individuals were deceased. But as a general rule, an individual at 1,000 nanograms per mil would theoretically be at higher risk, but there are other factors. I have seen individuals who are chronic methamphetamine users who are deceased at 1,000 nanograms per mil. There's overlap.
And you talked about affecting cognitive abilities. And I noticed that you were careful to couch your answers in possibilities. It could do this or it could do that. And that would vary from circumstance to circumstance and individual to individual. Is that correct?
To a certain extent, the point that I was trying to make there was that we can't look at a specific drug and concentration and say at that concentration of that drug the individual is going to behave this way. That is much too dogmatic. You're welcome.
Good morning, Ms. Carter.
Good morning.
Just to make sure we're on the same page, as far as timing your testimony, you wouldn't know whether someone had ingested meth, say potentially up to 3 days prior to that, based on their ability to metabolize. Is that fair to say? That they can test positive and have methamphetamine in their blood when they've ingested it up to several days before. I think generally 3 days. Is that fair to say?
What biological matrix are we talking about?
I'm not a scientist. I'm asking people who test positive for methamphetamine, that's generally a window of 3 days.
What specimen are we talking about? I need to know the specimen. In the blood?
Generally.
That's conceivable. Yes, it's possible.
Okay. When you say conceivable, the answer is yes.
It's possible.
Okay. And you can't tell how it affects a person specifically because you said you don't, there's too many variables in terms of how it metabolizes and tolerance and everything in between, correct?
No, that's not exactly what I said.
Okay. I mean, we can clear it up.
So it would be my opinion that the misuse of methamphetamine is associated with broadly one of two scenarios. Either the individual is actively under the influence on or about the time of the incident at hand, or they are coming down off of the drug in wait for their next dose. So tweaking, impairment on the back. There's impairment on the front side, and there's impairment on the back side.
And you can't tell which one.
I cannot tell from the concentration where that individual is without more information.
That's right. You wouldn't be able to tell if it was ingested up to 3 days prior.
I would not be able to tell that from the toxicology note.
Thank you.
Just briefly, but regardless of when the ingestion was, at 400 and 480 nanograms per milliliter, they are, as you put it, impaired either whether they're going up or coming down.
In my opinion, yes, sir.
Thank you. No further questions.
Anything further?
No, thank you.
Thank you.
Thank you.
Dr. Talas?
You may step down.
My name is Nicholas Ike Batalis, B-A-T-A-L-I-S.
Your middle name is Ike?
Yes.
That was my father's name and my son's name. I didn't know that. Dr. Talas, what do you do, sir?
I'm a forensic pathologist.
And what exactly is a forensic pathologist?
So forensic pathology is a subspecialty, a practice of medicine, a subspecialty that focuses on the medical legal aspects of medicine, predominantly performing autopsies to determine a cause and manner of death.
And how long have you been doing that?
I've been employed in my current position for approximately 15 years.
And what did you do prior to
I started my training attaining my undergraduate degree in biology at Butler University in Indianapolis, Indiana. I then went on to complete medical school at Indiana University School of Medicine, also in Indianapolis. After completing medical school, I moved to Charleston to the Medical University of South Carolina, where I completed a 4-year training program in general pathology. So general pathology is a field of medicine that deals with the diagnosis of disease. So if you were to have a tumor cut out or a biopsy performed, the pathologist would be the one to look at that and determine whether it's cancer or an infection and that type of stuff. A pathologist would also oversee a clinical laboratory. So if you have any blood work done, a pathologist would oversee the lab that's performing that sort of work. So after completing that 4-year training program in general pathology, I passed an examination to become nationally certified in pathology. I then went on to a 1-year specialty training program specifically regarding forensic pathology at the Dallas County Medical Examiner's Office in Dallas, Texas, where we spent that 1 year just focused on forensic pathology. Again, at the end of that year, passed a national examination to become board certified in forensic pathology, and at that point, I then took my current position.
So as a board certified forensic pathologist, have you testified in court as an expert in that field?
I have. It's over 100 times now in South Carolina, and I believe twice in Texas and twice in North Carolina.
Your Honor, this time we offer Dr. Nicholas Vitalis as an expert in forensic pathology.
Says the defense. He is so qualified in the field of forensic pathology.
Dr. Vitalis, I want to talk to you now about Cristina Pangalangan. Did you perform the autopsy on this individual?
Yes, I did, on August 7th of 2019.
Can you tell me about, from the standpoint, what do you know about the decedent?
Sure. So just a little bit of background. So at MUSC in Charleston, we perform autopsies for a number of counties across the state as needed by the coroners. So what the information provided to us in this case was what the decedent was a 13-year-old individual who was found unresponsive after being placed in a vehicle for several hours during a warm day.
Did you receive information that assisted you in what her body temperature was at the time of the scene?
Yes, the coroner in this case reported that the body temperature at when he examined the body was 109.9, which I believe was the maximum amount that thermometer would read.
How is 109.9 relevant to you in your determination?
When we're determining a cause of death, we have to determine a number of different factors, and certainly in a case like this, if we're considering whether the heat played a role, hyperthermia, we want to have some indication of what the body temperature was. At a fatal body temperature, the body will start to shut down around 105 to 106 degrees. So certainly having the information that at the scene the body was at least 109, 110 degrees would indicate there was evidence of severe hyperthermia.
And the body stopped shutting down. I know normal body temperature is what?
There's going to be a range. I mean, the most classical quoted would be 98.6. Some people would be 98. Some people may be in the 99 area, but somewhere just south of 100.
And so when does the body start shutting down?
About 105 or so. With heavy exercise, the weather we've been dealing with is not uncommon. People have fevers at times to get up to 102, 103, 104. But there seems to be a critical line somewhere around 105, 106 where the body will start to shut down.
Now, when we say the body is shutting down, exactly from your standpoint, what does that mean?
Again, our bodies are really designed to really function within a certain temperature range, and so all of our organs will eventually shut down if we are too cold or if we're too hot. Regarding the most immediate threats with heat would be the effect on the brain. So if the brain gets out of its normal temperature range, it's not going to be able to function very well. And again, our brains are a driving force that's going to drive our other organs, signaling those to function and that sort of thing.
In this particular case, I know you were called upon to develop a manner of death as well as a cause of death. What is the difference between those two things?
Sure. So a cause of death is, simply put, how the person died. So, for example, a gunshot wound or a heart attack. The manner of death would be how that cause of death came about. So to use a gunshot, for example, I'll step back for a second. For manner of death, we have 5 choices, essentially. We have homicide, which would be the death at the hands of another individual. We have a suicide, which would be somebody intentionally taking their own life. Accident, which is fairly self-explanatory, where the death is due to some sort of unpredictable measure. Natural, death due to natural disease or the aging process, or undetermined, where we can't figure it out. So a gunshot wound, for example, it could be a homicide. If you were to shoot somebody that, if you shoot someone else, if you were to shoot yourself, that could be a suicide. If you're out hunting with some friends and there's an unfortunate circumstance, it could be an accident. So a single cause of death could have multiple manners of death depending on the situation.
Your Honor, objection as to what I think is coming as to the ultimate issue.
Tell me the objection again.
What I believe is coming is testimony on the ultimate issue. Obviously, I know I can cross-examine, but my objection is to what I believe is the testimony.
I have to hear the question to be able to rule on an objection.
Sorry, Your Honor, he was called upon to determine manner of death and cause of death, and that's the normal pathology testimony under 703, and that's exactly what we're going to ask him, so that's the intent. So, from the standpoint of manner of cause of death as well as cause of death, what were your determinations?
My determination for the cause of death in this case was hyperthermia due to neglect, and the manner of death was homicide.
Now, let me start with, if I could, did you, by the way, when you perform an autopsy, do you also do a chart sort of contemporaneous with your autopsy?
Yes, we have a body diagram that we'll use to take notes and note our findings during the course of the examination to help us with compiling our report.
Let me show you what has been marked as State's Exhibit number 24. Is this the chart that you created?
Is that in evidence or no?
No, sir. Not yet.
Yes, this is a reproduction of the body diagram that we used as when we were examining the body and generating our report.
Okay, will that assist you in your testimony today?
Yes.
All right. And Your Honor, at this point, these are, in other words, these writings up here, these are your writings?
These are a combination of my writings. I also performed this examination with what we call a fellow, so another pathologist who was in doing their fellowship training, their forensic pathology training, who I was overseeing. We did this case in concert, so some of the handwriting is hers, some is mine.
Okay, and all of that's under your supervision?
Yes, I was present for the entire examination.
This time, Your Honor, we move State's Exhibit 24 into evidence.
Says the defense.
No objection, Your Honor.
I don't have a problem with it as a demonstrative, but I do have an objection to its admissibility.
All right, response.
He's testified to that this is the chart that he created in his performance with the autopsy. These are notes that were taken by him and his team during his supervision. It's authentic. It is relevant. Your Honor, we move it into evidence.
Our position has no problem. You can stand right up there and tell them all about it. They can see it. I just don't think it's proper as far as admissible in evidence. They can absolutely see it. You can tell them, and they can review it right there in front of them.
Okay, we'll rule later as to whether it goes to the jury room, but it's admissible at this time for demonstrative purposes.
Yes, sir. Now, I want to make sure everybody can see it. The doctor's house, I've now put this in a position where you can't see it. So let me ask you, if you can keep your voice up, but could you come down and describe to us what you have on this drawing?
Sure. So what we have here is a generic body diagram. At the top, there are just some general things that we're going to examine on every case. And we're performing an autopsy. Again, our goal is to determine the cause and manner of death. That being said, we start with an external examination where we examine the body from head to toe, essentially like a physical examination your physician would perform. So we're noting the height, weight, eye color, hair color, all those sorts of things. So those are noted up top. We then have a body diagram that we use to note any findings on the body. Again, it could be a scar, it could be a tattoo, or any sort of abnormal findings that we see during the course of the examination.
And what is the height weight on this, by the way?
This individual was 58 pounds and measured 56 inches in length. So I believe that would be 4 foot, 8 inches approximately.
All right, and you studied the medical records on this individual as well, did you not?
I've read through the records that were provided to me.
Okay. And can you tell us from the standpoint, she suffered from cerebral palsy, is that correct?
Yes, that was part of her medical condition.
And so from that standpoint, does that have anything to do with that weight? Or is that something that's standard for a 13-year-old?
No, this individual was certainly shorter than you would expect for this age, and definitely weighed much less than you would expect for a quote-unquote normal 13-year-old.
Go ahead, I'm sorry to interrupt.
I believe that was true.
All right. So after you get the general information, then these other drawings on the body, what do these indicate?
Sure. So the main findings externally on this the decedent were these areas where we kind of have these kind of ragged outlines here. There's one on the right elbow. This would be the right side of the abdomen. You can see there's some on the right thigh, some on the left thigh. Also, there's some on the left knee, and on the right back, left arm, right thigh. So these were areas of what we would call skin slippage. So the skin, essentially started to blister or pull away from the body. Some of these areas also had a really dry, yellow, orange, kind of leathery type of appearance. So certainly nothing we would see on a normal examination.
So in the context of those two, you've got the skin slippage and the blisters, you've got the leathery. What's the difference between the two?
So with skin slippage, we typically think that's part of the breakdown process of the body, what we call decomposition. So that's going to be determined based on how long an individual has been dead, but it's also really driven by the temperature. So when temperatures are high, decomposition is going to ensue much quicker than if the temperature is much lower. When we start to see the more leathery type of lesions, that tells us there was some sort of injury to the body, some sort of actually burn to the body. In this case, the reason it has more of a leathery appearance is because the body wasn't truly functioning well at that time. If somebody really has a burn, their heart is still beating, everything is vital, it's going to really have more of a reddish appearance, kind of more angry type of appearance. So when we see that leathery appearance, we know there's been injury to the body, but likely kind of during the dying process or even after death.
So what do those two tell you from the standpoint of the manner of death?
The fact that we have the blistering in the body, again, it would attest that there was increased temperature for an individual that's been dead for a limited amount of time, number of hours. You would not expect to see the skin slippage and blistering in somebody who was found at ambient temperature like we are here today. That's something that would really take probably days to start developing that slippage. So the fact that we saw that skin slippage would indicate there was a higher temperature. And again, with the more leathery appearances, that's probably likely the body was in contact with something that again caused more of a surface skin to the skin.
That's fine. Where are the exhibits? Sorry, excuse me. Don, I want to show you what's been marked as State's Exhibit. Actually entered into evidence as State's Exhibit 3. And I'll put it up on the monitor. Is this what you're talking about? These are pictures that have been testified at the crime scene of Cristina's leg. Is that what you're talking about with that? What can you tell me about those?
Yes. So may I have a
Can you see
pointer?
it well enough for me?
I can see him, but is there kind of a pointer or?
I'll tell you what, why don't you come down and just keep your voice up where everybody can hear you, and we'll do it that way.
Thank you.
Can you stand here? Will that be all right?
Sure.
Great. Don't want to get your way. Mine or your way.
So this photograph here illustrates the kind of two different lesions that we're talking about. So up on the upper aspect of the left thigh here, you can see there's this kind of wrinkled, very thin appearance, kind of wispy appearance to the skin. That would be more that what I'm speaking with was skin slippage, so part of the breakdown process of the body. But in addition to just that, we can see here on the lower part of the left leg, we have this lesion where the skin is more ulcerated away. We can start seeing some areas on the knee, on the leg, that appear different than up here where we don't have that appearance to it. So again, to me, that would say these areas were likely in contact with something in the area that caused a direct burn or injury to the skin. And then we also have areas, again, that just show there's decomposition that's going on.
All right, and can you tell us anything as far as the timing on any of that? You mentioned earlier something about you wouldn't expect that in a quick, or I'm not sure I would want to mischaracterize it.
Could you repeat the question with respect to the timing of what?
Yeah, the timing of it. In other words, how long does it take for a body to do this? How long does it give you any indication of anything like that?
The timing is going to be unpredictable because it's going to be heavily dependent on the temperature. So, again, in a temperature like this in the courtroom, you would not expect to see these type of changes for, again, possibly a day or two. But if there is a very high temperature of the environment, you can see this within hours of the death.
And these other chart things that you noted too, do they kind of fall into that same category as well?
Yes, most of what's charted on is showing these different areas where we have these areas of these burn areas and the areas of the slippage. The other thing that's noted on the chart is that there were contractures of the knee, of the knees, and so that was more part of her developmental issue, were the knees, because she was not able to walk around and use her legs like most folks. Essentially, the legs become more fixed. So that's one other thing that's noted on the diagram.
I'll let you get back to your stand. Thank you. Any other determinations as far as the external part of the body?
I don't believe so. I believe those were the main findings: the different areas of the skin slippage, the burns, and then the contractures of the knees.
Now, let's go to, I'm trying to determine, let me stay on the list just briefly. Some of that is, can you tell us if some of that is caused internally as well as externally? In other words, is there a difference between the internal heat causing some of that damage versus the body coming in contact with another hot item or things like that? Is there any way to tell that from those images?
Yeah, if the body is just heated internally, you're not necessarily going to see external areas like we saw on the leg where we had where the skin was missing. We had that more kind of reddish yellow appearance. Again, if the body's just overheating, you can get some of the more skin slippage. Again, usually that's going to occur after you die. Again, when the body's just overheating, typically you're not going to have the changes in the skin. So what we saw, again, with the areas on the lower leg, that would have been more of a burn that was in contact with something. So something more from the outside than coming from inside.
Now let me talk about, if I could, your internal findings as far as Cristina is concerned. What were those?
Sure. So the major internal finding in this decedent was an abnormality in the brain that's called polymicrogyria. So our brain has multiple kind of folds to it, and polymicrogyria is a descriptive term. So poly means multiple, micro means small, and gyri are basically the grooves of our brain. So she had too many of these grooves that were very small. So the solicitor mentioned earlier that she had a diagnosis of cerebral palsy. So cerebral palsy can be an end condition from a number of things, but basically when the brain is starved of oxygen, while the baby is inside mom or after kind of immediately after birth. So it could be caused by a number of different things, prematurity and various diseases. In this case, the polymicrogyria was her kind of initiating condition. So she developed that while she was in utero or inside mom. That led to oxygen deficiency at birth, around the birth period, that led to the cerebral palsy. So certainly the examination, the brain was abnormal, as it did show that unique finding. Otherwise, most of the organs, again, all the organs, I should say, were well developed. There was no evidence of any severe natural disease of the heart, lungs, any of her other organs. The other notable finding we did see as part of our examination of the internal organs was that she did have gastric contents or vomit that was aspirated down into her airways and into her lungs.
All right, can you tell us if that took place while she was alive or after she was dead?
That would have occurred probably during the dying process. After her brain had started to dysfunction and shut down, some individuals lose bowel, bladder function. Another thing would be to start vomiting. And so in this case, she would have vomited during the dying process, regurgitated some of that into her lungs.
You're finding hyperthermia. Did I get that right?
Yes.
What exactly is hyperthermia?
Hyperthermia is a condition in which the body shuts down due to extreme heat.
And when, and I think you testified earlier that begins at somewhere between 105 and 106 degrees, is that correct?
Certainly, anytime you're above, 101, you could be considered slightly hyperthermic, but when we consider a life-threatening condition, 105 to 106 would be considered a fatal temperature.
And her internal was 110.
At least 110, based on the thermometer reading.
The testimony previous in this courtroom is that the internal car temperature reached a maximum of 118 degrees and a heat index of 135 degrees. How long would it take somebody to die in that particular environment?
There's going to be some variability from individual to individual, but once the environment had reached that temperature, the individual would not live more than an hour.
I don't have any further questions. You answer any questions the defense have.
Yes, sir.
Thank you, Your Honor. And I'm sorry, Doctor, what was your last name, sir?
Batalis.
Vitalis. Dr. Vitalis, as a doctor of pathology, I mean, you're a medical doctor, an individual, correct?
Yes, I am.
And that's pretty much akin to being a scientist, the work that you do. I mean, is that fair to say?
Yes.
Now, as a scientist here to testify, you don't really, in a colloquial language, you don't have a dog in the fight. You're just here to say what the scientific results are, share your findings. Is that correct?
As a forensic pathologist, I view my role as being here to speak for those that aren't able to speak for themselves. So I'm here to explain the findings in this individual to show why they died.
So you're here to share with us the results of your scientific investigation or testing. Is that correct?
Correct.
And how many times did you say that you've been qualified as an expert to testify in court?
Somewhere over 100 times in South Carolina and a couple times in Texas and North Carolina.
We just talked about South Carolina. Were the 100 times that you've been qualified, were they in Court of General Sessions? And if I say Court of General Sessions, do you know what I mean?
Yes, they've all from there may have been one or two that were in federal court, but the vast majority were in General Sessions Court as we are here today.
And out of those 100 times that you've been qualified as an expert to testify, unbiased scientist, how many times have you been called to testify for the defense?
As part of my work as a forensic pathologist, there have been times when I've been subpoenaed by both sides, by the prosecution and defense, but again, the vast majority, if not every time when I've testified, it's been at the request of the solicitor.
So we've gone from the vast majority to every time. Every time you've been qualified to testify in court, you've testified for the state. Is that correct?
As I said, I believe so. There have been times where both sides had subpoenaed me, and again, since the prosecution goes first, I was called first by the solicitor, but had also been subpoenaed by the defense.
Okay. And for the last time, I'll just end my question. I don't want to know how many times you've been subpoenaed or who subpoenaed you. Certainly there are times when everybody subpoenas every name in the file. But every time your name got called to the witness stand, it was because some prosecutor called you. Yes?
I believe so, yes.
Now, you talk about determining manner of death and cause of death. Is that right?
Yes.
And when you talk about manner of death, I mean, I was trying to listen. I think you basically, I'm sorry, I want to talk about cause of death first. Cause of death is just a cold hard science tells you, is that right? This person died of bleeding to death, or this person died because he was shot in the head, or this person succumbed to pneumonia. Is that correct?
Yes, the cause of death would be, simply put, the main reason, the condition that led to the death.
Sherry.
And as far as cause of death goes, I mean, would it be fair to say that most of the time, as a scientist, you could do this effectively in a vacuum? What I mean by that is a deceased person is brought in on the table or however that is that you deal with, and you're asked to determine how this person died, the cause of death. You don't really need a lot of other information to do that, do you?
We certainly do in some cases. The way I would relate that would be if you went to your physician and you just said, examine me, you're not likely to get as detailed an examination. You're not likely to get the entire truth, entire findings. Whereas if you would actually report what your conditions are, I have a headache, I have chest pain, the physicians will be able to focus their examination and tailor it as such. So there are some cases, if somebody is shot 15 times, I would agree.
I'm not, I can talk loud, but do I need a mic? I will talk loud. And I'm sorry to interrupt you. We can go back to the beginning. I can rephrase my question if you need to, or you can pick up where you left off, sir.
I believe I can continue. So there are certain cases, if somebody is shot 10 or 15 times, the history is not going to be as important in that case. I'm going to understand that except a very rare circumstance, an individual is not going to shoot themselves that many times. But there are a number of other deaths, I can't put a percentage on it, but a large amount of the cases we examine, the history that's provided to us, the circumstances of the death, the scene investigation are critical in us determining our cause and manner of death.
So, thank you. So if I understand correctly then, you may just be presented with a body that's discovered somewhere with no history whatsoever, dead on the table, and say, I have no idea why this person died. Without someone else telling me or giving me more information, I can't say physically why this person is now dead.
I'm sorry, could you say that again?
Yes, sir. You seem to be telling me that despite the scientific training that you have, the experience that you have, being a medical doctor, specializing in autopsies, how many autopsies have you performed?
Somewhere between 3,000 and 4,000 at this point.
Okay, 3,000 or 4,000 autopsies, that without someone else telling you how this person was killed or passed away, you can't scientifically look at them, perform your experiments, your autopsy, your testing, and say this person died of a heart attack, or this person died of pneumonia, or this person died of being shot. Is that correct?
That's not correct.
Explain to me.
There may be information provided from the scene that we're not able to determine through the course of examining the body that would be critical in determining the cause of death. Again, we can look at the body, we can look at toxicology, we can look at all sorts of different things as part of our examination that we're doing as part of the autopsy, but sometimes there are findings based on the history and circumstances that reveal the critical cause of death.
Thank you very much. Now, let me ask you about this case. You can look at the chart again if you need to when we notice. If you were presented with what you were presented here, with the deceased child, and said, can you determine how this child died? And no one else gave you a sheet of paper with their opinions, their findings, or police reports, or et cetera. Would you look at this child and say, yes, you died of heat?
It's hard to imagine a hypothetical examination in which I would examine a body with no history whatsoever.
Well, let's take a moment and try to do that.
Okay, could you rephrase?
If you were presented with the corpse of this child and no other information, and said it's critically important that you look at this deceased person and tell us how they died, would you be unable to determine that they died from heat?
With no information based on the scene and circumstances and just examination of the body by itself.
Yes.
Is that your question?
Yes.
Is that including no history as far as how long the decedent had been dead before they were found? I've never experienced this in medicine where you're not provided any history, so it's hard to answer the question. If you can't answer the question,
you can't answer the question. I'll try one more time. This is assuming that you have never met this person, you have no paperwork in your hand, you've been beamed to another planet and presented with this child with nothing else and said, can you tell us what this person succumbed to? If you can't, you can't. If you can, you can.
So with no history whatsoever, examining this body, I would be concerned that there were the burn marks on the extremities that we've shown. Externally, that would definitely be a concern that there was some sort of, again, burn, some sort of environmental condition that could have contributed to the death. Examining the body internally, certainly the brain disorder, seeing that polymicrogyria would indicate that there was some natural disease that possibly could explain the death. But again, the circumstances would be critical in this case.
So yes or no?
I believe I explained myself as clearly as I possibly can.
Can you boil it down to a yes or no?
Can you ask again?
No, never mind. Thank you. Do you have any other causes of death that you can? You spoke about suicide or a homicide, and I think you referenced some natural cause of death, do you ever have on your sheet, and I'm sorry, manner of death, do you ever have on your sheet undetermined?
Yes.
Okay. And tell the ladies and gentlemen what that means.
So undetermined would be a manner of death where, simply put, after the end of the examination or autopsy, all the known facts of the scene, the circumstances, despite all that information we have, if we're not able to specifically determine which category, whether it's homicide, natural, accident, suicide, any of the other ones that we previously described, if we don't feel like we have enough information for that, some cases we will determine to be undetermined.
Okay. And I don't want to put words in your mouth, but it sounds like unless someone else gives you a bunch of information based on their experience or opinion, it's quite likely you can't determine the cause of death or manner of death. Is that correct?
I don't believe so regarding cause of death. Again, regarding this case, the circumstances that the decedent was found in a vehicle with very hot temperatures, I don't need some expert to determine that. Again, that's an indicator that there is going to be hyperthermia, we have burns on the body. Cause of death, no. Manner of death is going to be more critical dependent on the information that's provided.
That's the answer I was trying to get earlier. So as far as cause of death, in the absence of any other information, you could determine that. Never mind. Thank you very much. So when you're going from an undetermined cause of death to saying a homicide, what you're doing is reviewing all the information that is provided to you and factoring that into your opinion and relying on it. Is that correct?
Yes.
And in this case, the information that was provided to you was provided to you by or from various agents of the state. Is that right?
Yes, the majority of it was provided by the coroner, and again, I did review some medical records. I don't know what provider, but there was some healthcare records from a hospital or medical provider.
Okay, but it came from the coroner or police officers, as far as that goes, or various other agents of the state. Is that correct?
Correct.
Okay. And how long did it take you to review the information that you had before you went in to do your autopsy?
I don't recall. It looks like 4 years. I don't recall exactly how long that would have been.
Generally speaking, you think an hour, 2 hours?
Sometimes it's a matter of minutes, sometimes it's a couple hours. I don't remember in this specific case.
Okay. So at the outside, a couple of hours.
Prior to the case, yes.
Okay. And you don't have some sort of a litmus test where you can run a graph or a test and it pops up homicide. I mean, this is your opinion based on the information you had received at the time that you did the autopsy. Is that correct?
Not only at the time of autopsy, but again, our reports are issued somewhere between usually weeks and sometimes months after we complete our examination, where we have all the information, including our autopsy findings and any other information outside the autopsy. So sometimes, again, it takes several weeks or months after the autopsy.
Well, what information did you receive after the autopsy in this case, sir?
I don't recall the specific timeline.
Did you receive any information? You can look at your notes, your report. Did you receive any information subsequent to the autopsy? Or did you do the autopsy, prepare your report, write your opinion down, and move on to your next case?
No, with this case, the initial ruling regarding the death was that it was a pending cause of death and a pending manner of death. So again, after completion of the autopsy that day on August 7th, 2019, we were still considering. We wanted to see everything that was in play. We wanted to see the toxicology testing we'd ordered as part of the autopsy. We wanted to see the microscopic findings under the microscope and await any other investigative results. So it wasn't until everything else had come back. In this case, it looks like it was approximately a month to 6 weeks later before the ultimate ruling was determined.
Okay, so then your opinion as far as manner of death, which you've said homicide, is malleable. I think I pronounced it correct. Do you understand my question?
I'd like you to rephrase, please.
Your opinion as far as cause of death is just what you described, an opinion. That is, if you receive more information today or next week, it's subject to change. Is that right?
Certainly. When we issue rulings, again, whether it's undetermined, homicide, suicide, these could always be altered later on if additional information comes out that we didn't have at the time we made that ruling.
And you had reviewed notes, I think you said, for anywhere from 5 minutes to 2 hours and performed your testing. And that's what your opinion is based upon, as well as the toxicology results or whatever you received. Is that right?
And a review of everything after the fact. Again, I reviewed, for minutes to hours before the case. Again, after I did the case, again, would have re-reviewed the records, discussed it in peer review with our division. So much more thought went into the case before the ruling was issued.
I think I understand. So if you were to sit through a week's worth of information and hear from various parties and all interested sides, as well as from law enforcement, et cetera, subject to cross-examination, and glean and gather more information and more perspective, your opinion might change. Is that right?
If I could rephrase, are you saying if I was provided additional information regarding the death, could my opinion change?
I'm saying if you had another week's worth of information hearing from all sides and all parties and all positions, is it possible your opinion might change?
Certainly. As part of my examination, I take into account any information provided to me in making my rulings.
Thank you. No more questions.
Mr. Phillips.
Good morning, Dr. Vitalis.
Good morning.
And I guess to be clear, we know each other.
Yes, we do.
We have worked together before.
Correct.
And I just want to say, I don't question your credibility at all. And I think based on your testimony, I can clarify that. I've called you as an expert witness before. You might not even remember, but I have.
I know I've done some consulting for you. I can't remember the exact testimony, but yes.
So I'm not questioning your credentials. I'm not questioning anything regarding your findings. And we don't dispute, from our side, can't speak for the other, we don't dispute how she died, the hyperthermia. It's a hot car. We don't dispute any of that.
Is that a question?
Getting there, Your Honor. And with that, when you find homicide, that's not the same as the legal definition of murder, because there's different type of defenses like accident or mistake or even involuntary manslaughter. There's different types of homicide. Is that right?
Correct. When we speak of homicide in a medical term, it's death due to the hands of another individual. So an example, a homicide, if there was somebody illegally shoots another individual, that would be a homicide. If somebody's being attacked and in self-defense, they would kill another individual, that would still be a homicide, whereas that may not be considered murder in a legal context.
Right. So the self-defense in the shooting example you just gave is not a murder because it was a self-defense situation, but you would still have homicide listed as a manner of death.
I would leave the murder determination up to the legal system, but yes, I would be speaking to the medical determination of homicide.
So your testimony today, your opinion testimony of homicide is not the legal definition of murder. That's what we're here for. That's what they're here for. Is that fair to say?
Correct. There's a difference between homicide and murder.
Right. Because the manner of homicide doesn't say whether it's a reckless homicide or involuntary manslaughter or any of that. It's just based on, from a scientific standpoint, a homicide.
Correct. When I say homicide, it means the death was due to the actions or the hands of another individual.
Right. And it doesn't deal with any potential defenses or the type of homicide it could be, like a reckless homicide.
I'm not aware of all the legal variations of homicide, so I think we're in agreement, but I'm specifically referring to the medical definition, which is my realm.
Right, because there's not an involuntary manslaughter selection for you, right?
Correct. When we go to fill out, there's either homicide or suicide, or we don't have these other designations.
Thank you. Good to see you.
Anything further?
Thank you, Doctor. No, sir.
You may, anything from you, Mr. Lloyd?
No, thank you.
Thanks, sir.
Thank you, Your Honor. Everybody stay safe.
Yes, sir.
With that, Your Honor, the state rests.
All right, ladies and gentlemen, that's the state's case. We'll give you a break now. If you go to the jury room, please do not discuss the case. Are there any matters of law?
Yes, Your Honor. Well, I apologize. I jumped out of turn. Go ahead.
Yes, sir.
Your Honor, this time I move direct verdict on all charges. First, as far as conspiracy goes, there's simply no evidence of a conspiracy between the parties. That is, that they came together to accomplish an unlawful means. As a matter of fact, the evidence would indicate the contrary.
The evidence would indicate what?
That they did not come together to create a conspiracy, that is, to accomplish a criminal act or to accomplish something by criminal means. There's no evidence that they conspired. And so there's just no evidence of a conspiracy, and I ask the court to direct the verdict on those grounds. And as far as a murder goes, I think there's no evidence of a direct act on the part of the defendant, which would indicate malice or which could support a finding of malice. At most, according to the videotape that we watched, he placed a child in the car, placed the child in the care of his mother, he walked away. He's a legal stranger. He has no legal obligation before that to perform.
He's a legal stranger? Is that what you said?
To the child, yes, sir.
He's a legal stranger.
Yes, sir.
What is a legal stranger?
A legal stranger is a person who has no custodial rights to the child, no rights to visitation to the child, no rights whatsoever, as well as no obligations. He pays no child support. He's obligated to provide no care, no custody, etc. If there are problems within the family, DSS doesn't investigate him. Legally, he's a person who has never met or engaged.
Is that a term of art or one that you've created? Legal stranger.
Your Honor, it's a term of art, as I recall from my family court days, which we used in family court, which would be a legal term, and I think applicable here, and I think applicable to him also.
All right.
So I believe at the time, the evidence would show that at the time that he placed his child in the car, he did it without malice. The video clearly shows he did it gently, appropriately, put her in the car, walked away, and left her in the arms of her mother, or figuratively in the arms of her mother. That there was nothing about his actions to where the jury could infer or find proof beyond a reasonable doubt that he was acting with the malice. Subsequent to that, he had no duty to do anything else whatsoever. I don't think he can show malice by the failure to perform an optional duty at most. There's no legal imposition on him to act further. Once the child is out of his home, out of his care, out of his physical custody, if you will, and he has walked away. She is in the arms of her mother. Same argument would apply to the great bodily injury to a child, Your Honor. Thank you.
Yes, sir. Mr. Phillips.
Thank you, Your Honor. Be heard pretty good here. So, Your Honor, specifically, we would move for a directed verdict on all charges. I would renew all pretrial motions, specifically highlighting the 404B, 403 arguments related to Brittany Honeycutt and Lindsay Lewis. I followed up with a motion for the mistrial. I believed it rose to the level of manifest necessity to where Ms. Pangalangan has not received a fair trial, and we were asking at that point for a mistrial. So at this point, we would not only move for a directed verdict, renew all pretrial motions and arguments and objections we've made throughout the state's case. Specifically, as far as the directed verdict motion, as far as the conspiracy part, the law is that the state's case has to rise to a level of substantial circumstantial evidence to cross that burden to go to the jury. As to what's been presented to conspiracy, the state has not presented substantial circumstantial evidence of a conspiracy to survive that burden. It hasn't crossed that threshold. And for that matter, for conspiracy, we would specifically make that argument on that specific indictment as well.
Sir, thank you. Says the state.
Very briefly, Your Honor, I think the video itself establishes the elements of every crime. You've clearly got two people involved in putting the child in the car. With the temperatures, the testimony has been clear. That in itself is a reckless act. You move past that to 5 hours and 42 minutes where they leave that child in the car. You see on the video both of them going in or near the car, or around the car throughout that 5 hours and 42 minutes. The infliction of injury to the child is more than obvious from not only the pathology testimony, but also what you actually see in the crime scene photos from the standpoint of the murder. Again, this is on an implied malice under the Mouzon case from the standpoint of whether you even use the language that the defense has offered as extreme recklessness. I think you see that as you're watching the video. You see two people that literally do not break a window to get the child out of the car. They put a child in the car at this type of temperature and leave them there. You talk about temperatures that have exceeded what most people can even imagine. Throughout the entire time, these two people absolutely showing no care or concern for that child as the child literally cooks to death. And it's also clear they did it together. And you actually watch that on the video as well. So I think even from the just the very basic standpoint of the video itself, I think it establishes every element of every one of those crimes.
Any response?
Yes, Your Honor. Our position is that you don't have a negligent conspiracy. The state's theory is that it was a reckless disregard for human life, and with that, conspiracy is an intentional act. Their argument is an unintentional act, a recklessness standard. Obviously, my argument is under the true statement of law, it's extreme reckless disregard for human life, given the Watson case. But they're having two competing theories of recklessness, essentially negligence, and then conspiracy and intentional act. Those don't marry together. That's the basis for our argument.
At this stage of the proceedings, under Rule 19 of the South Carolina Rules of Criminal Procedure, on a motion of the defendant or on its own motion, the court shall direct a verdict in the defendant's favor on any offense charged in the indictment after the evidence on either side is closed if there is a failure of competent evidence tending to prove the charge in the indictment. In ruling on the motion, the trial judge shall consider only the existence or non-existence of the evidence and not its weight. In this case, there's testimony, if believed by the jury, that establishes that the death of Cristina was caused by the willful conduct, wanton, and extreme reckless conduct not extreme, a conduct that totally shows a willful or an absolute disregard for human life, and if believed by the jury that that conduct that caused the death was the combined conduct of both defendants. There's evidence of voluntary intoxication, which does not constitute a defense. As relates to conspiracy, there's a statutory definition where two or more people combine together for accomplishing a criminal and unlawful act or acts by unlawful or lawful means. That is a criminal conspiracy and does not have to be as a result of any expressed agreement, and it can be established through circumstantial evidence. The evidence shows that the parties were, if believed by the jury, would show that both defendants were working in concert with each other to the extent that conspiracy is a proper charge. has a great bodily injury on a child, whether or not death of the child was the proximate cause of the conduct of the parties. Certainly the pathologist's testimony establishes great bodily injury based on the autopsy, all of which is sufficient for the jury to consider each and every charge in the indictment. Therefore, the motion for directed verdict as to each party is denied.
And Your Honor, the rulings on the renewed objections motion to this trial.
Yeah, all courts' rulings during the course of the trial are the same. And further bolstered by the evidence presented during the state's case. So we'll take a few minutes. You ready to go with your defense?
Candidly, Your Honor, we were told, and I know the state will agree, that they thought they would take up the whole morning. I told people we get here about 11. We've already pinged them on the way. The state didn't anticipate going that fast.
Candidly, the court inquired whether you'll be ready to go when the state is over, is finished.
Once we do the inquiry as far as, I think, the colloquy with the defendants about whether they are going to testify, we will have witnesses ready.
Says Mr. Loy.
Your Honor, my experience was the same, and the answer is the same, but I did tell my client ahead of time that we would have the opportunity to have a meaningful conversation before he made a final determination as to whether or not he chose to testify. I would ask the court, and if he does, his testimony on direct would be relatively brief. I don't think more than 35, 40 minutes. I think
I'm not trying to rush anyone, except the state indicated they had a few more witnesses. It's not for the defense to project how long a witness's testimony will be, how long direct or cross-examination will be.
Your Honor, I'd ask for 30 minutes so that I can confer with my client and determine his decision as to whether or not.
You're entitled to confer with your client, and I'm required to engage a colloquy with each defendant as to whether they want to testify and not testify, and to confer with counsel on that issue. My point simply is, when the court gives instructions, don't rely on what the other side says, because you can't predict the time. I thought you all would take up all morning with some other witnesses too, but we're here and ready to go, and we're going to be leaving at noon. So
I would request 30 minutes for my client to make a final determination in this most grave decision in his life.
Well, it might take him 30, or it may take him less.
It may well take him less, but it would not take him more.
Okay.
If I may, Your Honor,
sir.
we got a text from my investigator. He had told the witnesses to be here this morning. My paralegal's going to step outside and make the phone calls. I just didn't want to speak out of turn. We're going to start making sure everybody's ready. So, and of course we have
one at a time for sure.
And we of course have the colloquy that needs to happen with the defendants. Thank you.
All right. If get the parties to stand. Now let's see. And be sworn. And we'll take a few minutes before engaging in this colloquy with the parties, so we'll take a few minutes at this time. Thank you. You may be seated. Did you see what you were looking for? Okay. Here. Let's see. So, Mr. King, if you'll stand for me. At this time, I'm going to explain to you certain of your rights. If you do not understand anything that I say, please let me know, and I will explain it in any further details that I might need to. Do you understand what I'm talking about? We've now reached the stage of the trial where you may present your defense. Now, you have the right to claim the protections given to you by the Fifth Amendment to the Constitution. This amendment in part states that no person shall be compelled in any criminal case to be a witness against himself. This means that you cannot be compelled or required to testify. You do have the right to testify on your own behalf, but no one can make you testify. This is a personal right, and no one can waive this right except you. Do you understand? If you decide to testify, you will be subject to the same rules that govern other witnesses, and you may be examined and cross-examined on any relevant issue in the case. In addition, if you have any convictions involving dishonesty or false statements, or for crimes punishable by imprisonment for more than 1 year, and I determine that the probative value of admitting this evidence outweighs its prejudicial effect to you, the solicitor will then be able to introduce your record to attack your credibility. If you decide to testify, this decision must be freely, intelligently, and voluntarily made with knowledge of the protections given to you by the Fifth Amendment and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It's left entirely up to you whether or not you testify. You may talk with your lawyer, family, friends, or anyone else, but the final decision will be left entirely up to you. Do you understand what I've explained? Do you have any questions about what I've explained?
Can you speak up? No, sir.
Have you discussed with your lawyer whether or not you should testify? Do you wish to talk with him some more at this time? Yes, sir. And Mr. Lawyer, you said you want up to a half an hour?
Yes, sir.
Has it a half an hour started?
No, sir.
Without a break? It hasn't started yet.
We started with the bathroom break.
Okay.
All people back in here waiting on the honor.
All right, very good. Well, we will give you an opportunity to confer with your client, and we will resume within that span of time.
Thank you, Your Honor.
All right. And Mr. Phillips,
I thought she came in first, so I saw her there. She's right here.
ma'am, if you'll stand for me. If you will stand for me. Ms. Pangalangan, at this time I'm going to explain to you certain of your rights regarding your right to testify. If you do not understand anything that I say, please let me know, and I will be happy to explain it further. Do you understand what I mean? We've now reached a stage of the trial where you may present your defense. Now, you have the right to claim the protections given to you by the Fifth Amendment to the Constitution of the United States. This amendment states in part that no person shall be compelled in any criminal case to be a witness against herself or himself. This means that you cannot be required to testify. However, you do have the right to testify, but no one can make you testify. This is a personal right of yours, and no one can waive this right except you. Do you understand? Now, if you decide to testify, you'll be subject to the same rules that govern other witnesses, and you may be examined and cross-examined on any relevant issue in the case. In addition, if you have any convictions involving dishonesty or false statements, or for crimes punishable by imprisonment for more than 1 year, and I determine the probative value of admitting this evidence outweighs its prejudicial effect to you, the solicitor then will be able to introduce your record to attack your credibility. If you decide to testify, this decision must be a free, intelligent, and voluntary decision made by you with full knowledge of the protections given to you by the Fifth Amendment and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It is left entirely up to you whether or not you testify. You may talk with your lawyer, Mr. Phillips, family, friends, or anyone else, but the final decision will be left entirely up to you. Do you understand what I've explained? Do you have any questions about what I've explained? Have you talked with Mr. Phillips about whether or not you should testify? Pardon? Do you wish to talk with him any more at this time about whether or not you should testify? Yes, sir. All right. Very good. The solicitor, with regard to possible impeachable criminal offenses, do you have anything on either defendant?
No record at all on Ms. Pangalangan. On Mr. King, there's some records, but nothing that I believe would be proper under impeachment. So, no, sir, we don't.
All right. Very good. And so we will give you an opportunity, certainly, to talk with your lawyers if your other folks.
Yes, sir. I know we have at least one here, and the others are in rounds.
Oh, okay.
So
Very
we're
good.
working on it.
Okay.
And as far as her decision, a lot that may depend on, obviously, since it's a joint trial.
Okay.
Thank
All
you.
right. We will be in recess, waiting for a word from the parties as to whether or not they're ready to go, or whether they're through discussing whether or not they're going to testify or not testify. Take a break. Ms. Pangalangan, have you had a chance to talk with your lawyer about whether you're going to testify or not testify?
Yes, Your Honor.
Are you going to testify?
Yes, Your Honor.
All right, thank you. Mr. King, have you had a chance to fully talk with your lawyer about whether you should testify or not testify?
Yes, sir, I am.
And have you made a decision?
Yes, sir.
Are you going to testify?
Yes, sir.
All right, very well, thank you. May bring the jury. Who's going first?
I will, Your Honor.
All right. I'm going to let you all have these verdict forms for your review and comment. So, one for each. What does it say? Pangalangan, that goes one to him and one to the solicitor. Yeah, let's see. Yeah, solicitor. And that's the other lawyer. Yeah, for the solicitor. No, it's to the other lawyer. Did he get two? He got two already. Okay. Madam Forelady, how's the jury doing? Very good. You have heard the state's case. It's now the defense's turn. Mr. Lloyd.
Thank you, Your Honor. Your Honor, we call Larry King to the stand.
How y'all doing?
No, sir. You don't get to ask no questions now. Just answer.
My name's Larry King, K-I-N-G,
And Mr. King, where are you from, sir?
from Walterboro, South Carolina.
How long have you been? Are you originally from Walterboro?
Yes, sir.
And how old are you, sir?
46 years old.
If you would, tell the ladies and gentlemen of the jury a little bit where you work. Do you have children?
Yes, sir. I have two sons, 23 and 21. I have a 4-year-old grandson. I worked for Big Group Technologies. I am now employed in Spartanburg for Renfro Brothers. I've been up there for 2 years.
Thank you, sir. Are you supported by anyone here in court today?
Yes, sir. I have my son over here on the far side next to my uncle, my mom's brother, his wife, my cousin, and my ex-wife.
Okay. And all right, thank you, sir. And you said that you have children, 2 children. Is that right?
Yes, sir.
Were you involved in your kid's life coming up? Did you raise them?
Me and my wife got divorced, but yeah, I was absolutely in their life. In 2014, they came and moved in with me, and they stayed with me on up till they got moved out the house.
Okay, so from 2014 on, you say you raised those children?
Yes, sir.
And you were involved in their life up until then?
Yes, sir.
Okay. Did you have problems related to that? Anything?
No, sir.
Mr. King, are you employed now? I think you said you were.
Yes, sir. I've worked for Renfro Brothers in Spartanburg, South Carolina.
Okay, and have you had a pretty steady history of employment?
Yes, sir.
What do you mean by that?
I've had 5 jobs in my life.
Okay. And have there been gaps when you didn't have them, or you always worked?
I always work.
Thank you. There's been a whole lot of talk during this trial about drugs, methamphetamine. You've sat through it all. Have you heard that?
Yes, sir, I have.
Well, you're not charged with a drug offense. You're not charged with anything to do with methamphetamine, but the state's wanted to talk about it a lot, so I'm going to ask you a couple questions about that.
Yes, sir.
All right? You doing okay? You all right?
Yes, sir, I'm okay.
Your Honor, do you need a drink or anything? Need some water up there with you?
I'm okay.
You decide you do, let me know. I think the court will indulge us on that, all right? Okay. So they've talked about this methamphetamine. Have you ever used methamphetamine, sir?
Yes, sir, I have.
Okay. And the witness talked about various usages people have. Do you have in the past, have you had a problem with methamphetamine?
I did.
And what do you mean? How did you define a problem?
I was a drug addict.
You were addicted to methamphetamine. Is that what you
I
tell me? If you were?
was addicted to methamphetamines.
Okay. And early on, during the selection of this jury, one of the jurors said they knew you and stood up and said they were in a 12. I guess they missed the anonymous part about Narcotics Anonymous.
Absolutely.
But one of them stood up and said they knew you from the 12-step program. Do you recall?
Yes, sir.
Okay. Have you, in the past, struggled with your addiction? Have you sought help? Have you tried to get help?
I did, and the last 2 years I moved to Spartanburg and in a Christian recovery-based center, and been in a program up there, and I've worked and lived in a recovery house, with other clean guys that were trying to, just been where I've been and trying to put the Lord first and do the next right thing.
All right. So, you look a little different today than what you did in the video that most of us watched. I know you didn't watch it, but you look like you put on some weight or some size. Is that right?
Yes, sir.
Does that have anything to do with your recovery?
Yes, sir. Just putting God first, getting clean, and trying to be more of a family man and doing the next right thing.
And when the doctor was talking, she said that methamphetamine or methamphetamine had sometimes been prescribed for weight loss. Like I say, you don't look like you've lost any weight since then. Have you put weight on?
Yes, sir.
Are you healthy today?
Yes, sir.
Are you clean today?
Yes, sir.
How is it that you can tell the ladies and gentlemen of the jury that you've always worked, you've had 5 jobs in your life, you've always been gainfully employed, and in the same breath tell them that you were a drug addict, a methamphetamine addict?
I was a functioning addict. I used daily to function, and it was just a part of my life. And,
when you say you used as a functioning addict, tell me what you mean.
I had to have it to go. I had to have it to work. I used it to do anything I done.
And were you able to work when you used this substance?
I was.
Were you able to drive or whatever, just to meet your normal obligations?
I did.
Okay. And she talked about tolerance. Had you used enough of this stuff to develop a tolerance to it?
Absolutely.
Okay. And you said day to day, as a functional drug addict, you used enough of this substance to keep you going and allow you to function normally?
I did.
Okay. And did that condition, and I understand you said you'd been in the 12-step program and you had sought some help prior to that, but did that condition continue at least off and on up until the day we're here talking about?
Yes, sir.
Okay. And subsequently, you've gotten to where you've described today. Is that right?
Thank God. Yes, sir.
All right. Thank you. Do you know, lady seated at that table over there, Miss Pangalangan? I think I'm saying it right.
I do.
Okay. And how do you know her?
We used to date.
Okay. And when did y'all first commence to date?
2015.
Okay. And did that last as a continuous relationship up until the day on this, or had y'all had times apart?
No, we dated for a few years, and we had broke up 6 months prior to, we started back talking about 5 weeks up to this happened. Yes, sir.
So y'all, you say you started back talking about 5 weeks prior to this day?
Yes, sir.
The day in question?
August 5th. Yes, sir.
Did y'all live together?
No, sir.
Okay. And you know where her home was?
Yes, sir.
About how far was that from your home?
Probably 15 miles.
15 miles or so?
Maybe, yes.
And you knew but you knew this little girl?
Yes, sir.
As far as the child goes, had you observed the other defendant? I'm just not going to try with the name. But had you observed the other defendant and her interactions with this little girl?
I did.
Okay. And was there anything about what you saw with the way she treated the child or took care of the child that caused you concern?
No, sir.
If you had seen things like that where you thought caused you concern, what would your reaction have been?
I would have got away from her. I would have left her alone and probably reported her.
If you were in a position where you did observe a child, not hers, but just someone else out in the world, a child who was mistreated or treated badly at the hands of another person, a man or a woman, what would your reaction be?
I'd address it immediately.
What do you mean by that?
It depends. If I seen a man abusing a child in any way,
Stop it.
Yeah, I'd stop it.
All right. On this particular day, you didn't. I noticed you didn't watch this tape in court. Is that right?
I didn't.
Have you ever watched it?
No, sir.
You lawyers have had it forever. Why haven't you watched it?
So I just can't.
Even prepping to come here today, did you watch it?
No, sir.
The state has the witnesses for the state have attributed statements to you or the other defendant, which say that she spent the night before this child died at your home. Is that correct?
Yes, sir.
And was Cristina there also?
Yes, sir.
Okay. And you said that you had talked to or been involved with Miss Pangalangan. Can't help myself. In the past, what was your relationship with this child?
She was just my girlfriend's daughter. Yeah.
Did you? This is a child who had special needs and needed special care. Did you wash this child? Did you bathe this child? Somebody did. Did you?
No, sir.
And it's tough, but this child was in a diaper. This young girl wore a diaper and wasn't able to clean herself. Did you clean this child? Did you change her diaper? Were you responsible for things like that?
No, sir.
Did you feed this child?
No, sir.
Did you put her to bed or get her up in the morning?
No, sir.
Were you financially responsible? Did you pay any child support or anything for this child?
No, sir.
And this may have been answered, but was she your daughter biologically or anything like that?
No, sir.
Okay. Regardless, the night before they spent that night at your home, is that right?
Yes, sir.
And tell me how in the morning you got up and you and did you go to bed that night?
No, sir. I'd been up all night.
Okay. Was that partly due to that methamphetamine use?
Yes, sir.
Okay. And when you got up in the morning, did you and the other defendant have a conversation which led to what we saw on the porch, that is you carrying the child out?
Yes, sir.
Okay.
Yes, sir.
Tell the ladies and gentlemen what that I don't want you quoting it, but just tell them what the conversation was about.
Just about her being involved with somebody else, and we had talked about it, and some things broke my heart, and I just asked her to leave. And
all right. So it was about basically what you would call infidelity. Is that right?
Yes, sir.
Okay. And in the course of that conversation, did she confirm that, yes, that had happened?
Yes, sir.
Okay. And when she said that, yes, that had happened, What was your reaction?
I was just hurt.
You were hurt?
I was hurt.
And what, that was your reaction. What did you do then? I mean, what did you say or what did you do?
I asked her to leave, told her I'd call her later.
Okay. Did you lose your temper? Did you smash anything? I mean,
Absolutely
you're a
not.
big fella. I mean, you were a big fella even then, but you're big now.
Absolutely not.
Okay. You didn't break anything in the house? Did you grab her or shake her or anything?
No, sir.
Okay. You asked her to leave.
Yes, sir.
And did she agree to leave?
Yes, sir.
Okay, and then what happened next?
I put a child in the car.
All right. Well, you say you put the child in the car. Did you carry her out?
Yes, sir, I did.
Okay. And why were you the one to carry her out?
Rita has a extra kidney, has a lot of trouble, health trouble, and her daughter was getting heavy for her, and so she asked me to carry her.
Okay. And thinking back, and I know you say you hadn't watched that tape, but thinking back, would there have been anything inappropriate, wrong, or rough about the way you would have treated that little disabled girl?
Man, absolutely not. Never.
Can you imagine a circumstance where that would be your reaction?
No, sir.
Okay. So you stated you carried the child out, and we've seen the tape. Placed her in whose car?
Rita's car,
Okay. And where did you put her in the car, if you recall?
and behind the driver's seat, on the driver's side, in the rear.
Okay. And you stepped away then? Did Mom come and, like, get her settled or seatbelt or something like that?
I think so, yes, sir.
Okay. And think carefully. Well, if you need to. Was the car running when you put the little girl in?
Absolutely.
Okay. You say you're from Walterboro, is that right?
Yes, sir.
We know, we've heard, and everybody else knows it gets hot in Walterboro, yes?
Yes, sir.
And you grew up here. I know the state went to great lengths to prove to the ladies and gentlemen of the jury that if you park a car in the sun in the summertime in Walterboro, it gets really hot. It gets too hot. Were you aware of that before the scientists testified?
Yes, sir.
You figure everybody in Walterboro who's got a car knows that happens, whether or not they hear from that scientist?
Absolutely.
All right. Would you have left that little girl in that car if that engine wasn't running and the AC wasn't on?
Never. Never.
Even with your feelings hurt, sir?
Never.
All right. So, you put the little girl in the car and you say the engine was running. Can you tell me what happened next? Just next.
I went back inside.
Okay, well, did you and she have a Let me ask you this. Up until the time you all discovered that little girl's body, was there anything unusual or scary about this day?
No, sir, it was another normal day. I thought everything was, I had no idea that anything was not normal.
Were you trying to memorize the events moment by moment?
No, sir.
Are there things about that day that you may be a little unclear on or foggy at this point 4 years down the road?
Absolutely.
Well, if somebody told you they watched that tape and you and Rita had a conversation in the yard after that child was put in the car, is that something you would deny or something you would just say, I don't recall it?
No, I remember
Okay, well, I'm asking you about that conversation.
asking her. I just asked her to leave and told her I'd call her later. That's all I asked.
Okay. And did she, in fact, get in the car and leave?
I didn't know, sir.
Excuse me?
No, sir.
Okay. What did happen?
She followed me back inside.
What were y'all talking about at that? You'd ask her to leave. She didn't leave. What was going on between you?
She was just trying to plead with me and talk to me and just trying to make things right.
Okay. And did y'all talk back and forth about it?
A little bit, yes, sir.
Okay. You said you had your feelings hurt?
Yeah.
Well, you said you was heartbroken.
Oh, yeah.
Okay. And while y'all was in the house, we just put the cards on the table. Did you make up?
We did.
Okay. And you decided to move on?
Yes, sir.
All right. At some point in time, and you don't have to give me minute by minute because ladies and gentlemen of the jury have seen the tape. They know how long things took and et cetera. But at some point in time, did the defendant at a other counsel table did she attempt to leave?
Yes, sir.
Okay. And what happened when she tried to leave?
She came back in and told me her keys were locked in her car.
Said the keys were locked in the car?
Yes, sir.
And what was your reaction to that? Not my problem. You cheated on me. Get out of here.
No, I tried to help her get in the car. I didn't know that anything other than that was wrong, to be honest.
Okay. Was the car still running?
The car was running.
Were you worried about the situation?
No, sir. Not really.
Okay. And if you had known, and I know you've seen what we've all seen, if you'd had any inkling that that's what was going to happen or was happening, what would your reaction have
Man,
been?
I would have knocked that window out of that car and got that child. I had no idea.
Ah. So you made an effort to get the child out of the car, is that right?
Yes, sir.
Or to get the car open. Were you successful in that?
Not right away, I wasn't.
Okay. And how you tried is not important, but do you recall what you did to try to get into the car?
Some of it, yes, sir.
What did you do?
I tried to get in. I think I tried to pry the door. I tried to. I offered to knock out the sunroof, but Rita didn't want me to do that.
You say you offered to knock out the sunroof?
Yes, I did.
Not your car?
Not my car.
Okay, but you offered to knock out the sunroof, and she said no?
Yes, sir.
Do you recall what she did say other than just no? Or it's 4 years later. I know you didn't remember.
She
Objection here, sir.
Repeat the question.
Did you ask her if she want? Your answer was, excuse me, earlier you stated.
Repeat the question.
I'm going to take a different question if it's okay.
Pardon?
I'm going to take a different question if it's okay, Your Honor. Your answer earlier was you offered to knock out the sunroof. Is that right?
I did.
After offering to knock out the sunroof, did Miss Pangalangan respond? No, I'm not asking what her response was. I'm asking, did she respond?
She did.
And after her response, did you knock out the sunroof?
No, sir.
Thank you. Did y'all then come up with a different plan?
Yes, sir.
And what was that?
She said she had a spare key at her home.
Okay. And were you at this point just done with the operation, or do you continue to try to help?
I continued to try to help.
And what did you do to try to help?
I went and took her to get another spare key.
Okay. And when you left, was the engine running?
Yes, sir.
And was it running when you got back?
Yes, sir.
And did you think that AC was on?
Yes, sir.
When you got back and you had that key fob, and did y'all retrieve a key fob?
She did.
Okay. And when y'all got back, were you able to pop the, just pull up with the key fob? Did that solve the problem? Did you pull up, hit the fob, and unlock the door?
No, sir.
Why not?
I think the batteries were weak in it. It wasn't working.
Okay.
It wouldn't unlock the door.
So y'all hit it, unlock, and it wouldn't unlock it?
Yes, sir.
Had a real problem now, or at least she had a real problem. Is that fair?
Yes, sir.
What did you do to address that?
I called Robert from Stokes Lock and Key.
Do you know someone there?
Yes, sir. Robert, the owner.
Okay. So you called the owner of Stokes Lock and Key, and what was the purpose of that call?
So he could help me get in the vehicle.
And if in fact you made that call, would that be reflected on the videotape? I mean, were you in the yard when you made that?
Absolutely. Yes, sir.
Okay. So you called Stokes Lock and Key, and you spoke with a person you knew there and asked how to get in the car. Is that your testimony?
Yes, sir.
And what did he tell you?
Told me it was an emergency key and a key fob.
Okay. And the emergency key and the key fob, people may know what that means, but apparently you didn't at the time. So what does that mean?
It was a key inside the fob that you separate it and pull out a key.
And you were never able to unlock it automatically.
Never.
But after speaking with the gentleman at the Locksmith company, what did you do?
He told me to told me to retrieve the key. I got the key and told me to pop off the face off the door handle socket, unlock the car.
And were you eventually able to unlock the car?
Yes, I did.
And it wasn't with that key fob?
No, sir.
It's just old-fashioned, stick it in and turn
Yes,
it?
sir. Yes, sir.
Okay. And I'm not going to ask you to describe what you saw when you got in the car. People saw that on the video and in the pictures themselves. But when the child got out, or the child was taken from the car and you knew she was deceased, what was your immediate reaction?
Call 911.
Did it occur to you that maybe you were in trouble?
No, sir.
Anytime during the course of this investigation, speaking with police officers, speaking with anybody else who talked to you about it, were you like, oh my goodness, I need to cover something up?
Never had idea, man. No,
Excuse
sir.
me?
No, sir. No, sir.
Okay. So you called 911, and when the information you gave them, was it correct?
Yes, sir.
And when law enforcement arrived, did you talk to them?
Yes, sir.
And was the information that you gave them correct?
Yes, sir.
Before law enforcement arrived, if we watch that video, it looks like the front door is open. You reach in for a minute. Are you grabbing something out of that front seat of the car?
No, sir. I reached in to turn that car off.
How'd you turn it off?
A button.
It's got a push button on it?
Yes, sir.
So you watch that tape. We should see you reaching in and turning that car off.
Yes, sir.
Okay, thank you. The vehicle itself, are the windows tinted in that car?
Yes, sir.
Are they a dark tint or just like a
Very
that
dark.
comes from the factory?
Very dark.
Can you see in that car?
No, sir.
When law enforcement got there and later they took you down to the police station, is that correct?
Yes, sir.
Did anybody ever tell you, you don't have to talk to us, you got a right to remain silent, all that sort of thing?
Yes, sir.
And did you sign the form and say, I understand it?
Absolutely.
And then did they keep talking to you for several hours?
Yes, sir.
Did you talk until they said you don't need to talk anymore?
Yes, sir.
Did you ever lie, try to cover up for
Never.
yourself?
Never.
One moment, John. You're charged with murder. Did you murder that child?
No, sir.
You carried that child to the car and put her in the car. You're accused of causing great bodily injury to this child. Do you feel like you handled her correctly and appropriately?
Yes, sir, I did.
I asked you earlier, is there any way that you'd cause harm to any child?
Never. I love children.
And for some ungodly reason, I have no idea still, you're charged with conspiracy. You're aware of that?
This jury is disregard the comment of counsel. Pose questions.
Thank you. You're also charged with conspiracy. Is that correct?
Yes, sir.
Did you and, I'll say Rita, with no disrespect, did you and Rita get together and plan some way to kill this child?
Absolutely not.
Did y'all get together and plan some way to hurt this child?
No, sir.
Can you imagine a circumstance that could have occurred?
No, sir.
Mr. King, these other lawyers probably got some questions for you. Try to answer them best way you can, all right?
Yes, sir.
And again, are you good?
Okay.
I say now, in the order, who's cross-examination, who goes first?
Which way do you want to go, Your Honor?
I don't know, I'm posing. Mr. Phillips, do you have cross-examination?
I'll be glad to go, Your Honor.
All right.
Let me make sure I understand your testimony, and I guess this is either based on your memory of the event or your comprehension of the event at the time, right? Your testimony today? You haven't looked at the video, you haven't
No,
done
sir.
anything. This is either from your memory of what happened or from your comprehension of that while it was happening. Is that fair?
Yes, sir.
You would agree that everything that was done to that child was done with you and Rita. Is that fair?
Yes, sir.
You put the child in the car, Rita was standing there when you did, correct?
Yes, sir.
You were standing around the car with Rita when the child was inside the car, correct?
Yes, sir.
You went inside.
Ask the witness to be allowed to answer.
He did. You went inside with Rita, inside the front porch together, did you not?
We did.
Pardon me?
I did.
And while you were in there, the child is still out in the car, correct?
She was.
Now, is it fair to say, and I know we've had some testimony, it was a pretty hot day, it's in August, your house, correct?
Yes, sir.
And your house is outside, the car was parked actually, it wasn't under shade, wasn't it was in direct sunlight, is that fair?
Yes, sir.
Okay. Now, when you called 911, as you did, first of all, and I want to make sure I'm clear about this, you say that from the standpoint of turning on and off the car, when you put the child in the car was on, but you turned the car off after you got the child, or after you, both of you got the child out of the car, is that correct?
Yes, sir.
Okay. And you're sure about that?
Absolutely.
Again, based on either your memory or your comprehension of the event that day, right?
I'm sure about that.
Okay. You got a security system that works really well in that house, do you not?
Yes, sir.
It's actually pretty sensitive, is it not?
Yes, sir.
It's got some infrared, it's got some other stuff, it's picking up everything. And all those are run cameras around your house, right?
Yes, sir.
In fact, I think at one point in time you could actually see a bug fly by and set the camera off, right?
Yes, sir.
And it was motion detected, correct?
Yes, sir.
So if there's any motion around your house, it's going to pick that up, right?
Right.
Okay. Let me go to, if you could go to 11:15 on the camera. Rita came back to your, all right, first of all, you were with
John,
Rita.
can we wait till 11:15? That's what he's going to address.
You were with,
John, could I get a ruling?
Overruled, proceed.
thank you, Your Honor. You were with Rita starting that Friday, is that right?
Yes, sir.
In fact, you went over to her house, just like I think Ms. Honeycutt or Ms. Lindsay said. You went over to the house and picked her up in your truck, correct?
Yes, sir.
Took her back over to your house. She was with you. That would have been Friday, Saturday, and Sunday, correct?
Yes, sir.
And then at some point in time, Sunday, she went back and got the child. I guess it was in the afternoon because you had to take her back over there.
Yes, sir.
And that was later in the afternoon, right?
Yes, sir.
So she was with you that entire time.
Yes, sir.
This is at the same time that I think you also said you were on pretty much a meth bender, were you not?
I was.
You were.
I was.
In fact, you were using constantly, were you not?
I was.
And in fact, you also said you hadn't slept in a couple of days at that point, right?
Yes, sir.
Do you remember the last time you slept up until that point?
I think it was Thursday or Friday.
Okay, so for Friday, Saturday, Sunday, you are doing meth all 3 of those days when you're staying up. Rita doing that with you?
I don't recall.
You sure?
Yes, sir.
You gonna stick with that?
Your Honor, that's the answer. That's the problem.
Objection.
I apologize.
Overruled, go ahead.
Yes, sir, I'll rephrase it. Did you not tell law enforcement that Rita, in fact, likes to put her meth in her coffee and drinks it that way? Did you not tell them that?
Maybe I did.
May have mentioned that. Okay. She's with you the entire time on this 3-day bender. You're using meth. Your testimony, you don't remember if she was using it or not, but you know that when she does use it, she puts it in her coffee? That's your testimony?
I speak for myself, sir.
Well, unfortunately, you answered my question, sir. So my question was, when you're doing the meth, is Rita doing it with you?
She was using.
Thank you, sir. Can you back up, please?
No, I want to see the spirit.
I'll get to that. I'm not anywhere close yet. So on this 3-day bender that you and Rita are on, did she sleep at all, or were you both up the whole time?
She slept.
Okay. So you heard the testimony from the, actually the toxicologist that talks about, and she actually talked about your under influence going up and coming down, and in fact, I think she even actually mentioned that while you're on it and taking it, you're staying up. That's not unusual. So that's pretty consistent with your testimony of what happened to you. Is that right?
Yes, sir.
Would you also agree that when you're on meth, and I know you're not on it today, but let's make sure you were on it these days, right?
Yes, sir, I was.
It's fair to say that you had problems with your decision-making, your critical judgment, your cognitive abilities.
Yes, sir.
So everything she testified to as the effect of methamphetamine was pretty much what you were experiencing. Is that correct?
Yes, sir.
And in probably, in fact, including the increased libido?
Yes, sir.
Objection, it's irrelevant.
Objection is overruled.
In fact, when you went into the house with Rita for about an hour or so like this, I think you told the council y'all were making up. You're going inside to have sex, were you not?
We did.
And that's while the child's still out in the car.
In the air condition with the car running.
Okay, well, let me go back now to turn the car was on when you put the child in,
Absolutely.
and you turned it off before the law enforcement got there.
Yes, sir.
You go to 11:15, or is that somewhere like that? Can you see the monitor from where you're standing?
Yes, sir.
That's the car we're talking about, correct?
Yes, sir.
This is your front porch.
Yes, sir.
And speak into the microphone so these.
Yes, sir.
And you also testified that your monitor is pretty sensitive, so it's picking up. I was just picking up motion now, but we really can't even see. I guess that's from the moss or anything like that. Any of that stuff is going to set it off? Pretty
Possible.
sensitive.
Possible, yeah.
And were you here when the officer testified that up until this point, there had been no motion around that car?
Yes,
Of course,
sir.
when you picked her up from the house, you took her back to the house, and she came back. What time did she get back?
I don't know.
I mean, it was at night, though, right?
Um,
Like Sunday night?
I think, yes, sir.
Okay. I'm just going to ask you while we're waiting on that. The car's not on now, is it?
I'm not sure.
Right. This is you and Rita coming out of the front door?
Yes, sir.
This is you carrying the child?
Yes, sir.
Can you pause it right there for me, please? Thank you. When Rita came back to your house that Sunday night, did she have her child with her?
Yes, sir.
Did she bring the child inside the house?
Yes, sir.
Would this have been sometime, around 8 or 9 o'clock that Sunday night?
I don't recall, sir.
Or wasn't midnight, was it?
No, sir.
And she brings the child in with her, does she not?
Yes, sir.
She go back out to the car after that? She just stay with the child and you?
I don't remember, sir.
When did, that Friday night, did she go to sleep?
Did she go to sleep?
Yeah.
Yes, sir. She lay down.
What time did she get to sleep?
I don't recall.
All right, go ahead and play it. This is you and Rita in the back of the car, is that correct?
Yes, sir.
Pardon me?
Yes, sir.
Back door is open, correct?
Yes, sir.
Front door is not open, is it?
No, sir.
Is this the first time you and Rita had gone out to the car that day?
That I'm aware of, I think so. It's the first time I did.
Is this you and Rita together?
Yes, sir.
And I'm assuming this is when you're upset with her because she cheated on you, right?
Yes, sir.
Pardon me?
Yes, sir.
Now what I'm going to do is I'm going to fast forward this, and I'd like you to just keep watching it, but let's fast forward the speed since we already know what's on it. See this, or if this goes too fast, you let me know, sir, please.
Yes, sir.
watching this, when you called on one, you actually said that Rita put the child in the car, did you not?
I don't remember, sir.
No question, you're the one that put Rita in the car, correct?
Cristina, yes, sir.
You also told the 911 operator she'd been in the car maybe 1, maybe 2 hours?
Yes, I wasn't sure. I looked at Rita and when I was asked that question, if you see on the video, and she give me that time. I had no idea how long she'd been in there.
Think that's the effective method, or were you just trying to minimize it?
I had no idea, sir.
Okay. Talking about? Do you remember?
Not everything. I was exhausted that morning, sir.
Do you recall if you were arguing at this point or making up or anything?
No, sir. At that point, I was asking her to just go, and I would call her later. And I think she was just.
Could Your Honor ask the witness to speak up just a little?
Speak up, sir.
Yes, sir. At that point, I was still asking her to leave and trying to convince her that I would call her later. I was exhausted, and I just didn't want to deal with it at that moment.
inside. Is that right?
Yes, sir.
And I know you haven't seen the video, but it would surprise you that you stayed inside the house for about 30 minutes or so after that.
I guess.
Okay, and you don't come back out for a while, going back out there at all, do you?
No, so I laid down.
Okay, when the video speaks for itself on that, you lay down. Y'all were going back in just now. Were y'all going back in to have sex?
We went in, I think, to make up.
Pardon me?
We went back in to make up. Yes, sir.
When you turned the car, according to your memory, when you turned the car off, according to you, before the police got there, you reached in the front door and pushed the button?
Yes, sir.
You just watched this video?
Sir.
You've got a sensitive, motion sensor camera that picks up everything with infrared lighting and the whole bit. In fact, bugs that come up pick it up. There was no motion on that camera up until 11:15, which the motion that was set off is by you and Rita walking to the car. Did you see anybody go into the front door of that car during this time that we just looked at?
No, sir.
Nothing else?
Ms. Phillips.
Mr. King,
Yes, sir.
when you called 911, your immediate response was, "Oh my God."
Yes, sir.
You were in a state of absolute shock.
Absolutely.
Your next response, they said, what is the address of your emergency? Hey man, I got an emergency, real quick. There wasn't any intent to cover up anything at this point.
No, sir.
Because there wasn't a plan to do anything.
No, sir.
So your initial response was to call 911. Your initial response to the operator answering your call is to say, "Oh my God."
Yes, sir.
Your next response, "My daughter was locked in the car. She had the AC on. My girl locked the keys in the car. We had to run her house to get the key fob and come back."
Yes, sir.
All right. What you need? Y'all can pull it up to, what was it, 12? 29, 30. Now, Mr. King, I understand you didn't come back outside, but Rita did.
Yes, sir.
I'm trying to excuse what happened, but Rita did come back outside.
Yes, sir.
That's Rita coming out of your house.
Yes, sir.
That's Rita opening the back door, checking on her. Or, excuse me, that's next. That's actually Rita sitting down in the front seat of the car. Now you see a time miss because there wasn't any motion. It's actually done. You want to go back one second? Thanks. So, a little bit farther back. Thank you. So at 12:29, Rita comes out and sits down in the front seat of that car. And she doesn't obviously get out immediately because the camera skips because it's a motion censored camera. So she stayed in the front seat of that car for a period of time. And you don't know whether she cut on the car at that point, right?
No, sir, I don't.
Because she went out to check on her daughter.
Yes, sir.
All right, now she comes back. She's been out of the front seat, and she opens the back door. She says something to Cristina. looks at the gauges of the car. You see her pause and look in
Yes,
front
sir.
before she closes. And one more time, if you don't mind. That last part. Thank you. So we have Rita sitting in the front seat for a period of time, then Rita getting out, then Rita opened the back seat, and then the front door again, looking at the gauges, and walks back in.
Yes, sir.
That's what the video shows.
Yes, sir.
Thank you. Again, this should have never happened.
Absolutely.
Mistakes were made.
Yes, sir.
You both should have done things differently.
Yes, sir.
Now, you told Officer Vonerdorf that Rita loved her to death.
She did.
Is that true?
It is.
Is that your hand on the Bible to God? She loved her daughter?
It is.
And that's your statement here today as it was then,
Yes, sir.
on the scene to the police.
Yes, sir.
You saw how she acted with her daughter.
Yes, sir.
Would Rita have wanted Cristina to die in any way, shape, or form?
Absolutely not.
Now, there was a phone call made to Eddie Hayward. And what did y'all call Eddie Hayward about?
Stokes, Lock and Key.
Two different people. So, again, you had, well, I guess she meant, that's for her. I'll stay with you.
Yes, sir.
You called Stokes Lock and Key, the local locksmith.
Yes, sir.
And how did that go?
The key fob wasn't unlocking, it wasn't working. I guess the batteries were weak. So he gave me instructions and told me where Mert's key was and told me what to do to get inside the car.
Now, the jury saw yesterday y'all shaking the car. There hasn't
Yeah.
been any explanation for that because that seems strange. You found that out through Robert Erebus.
I'm thinking so, yes, sir.
Well,
I didn't remember really shaking the car, but my attorney had addressed that.
It's in
So
the-
I'm assuming that maybe he might have said something to maybe reset. I don't.
well, they'll hear from Robert in a minute.
Yes, sir. Yes, sir.
Now, with that, at this point, your position clearly is that Rita loved her daughter to death.
She did.
And there was absolutely no position in y'all's part in terms of wanting Rita to die. That's clear.
Christina, absolutely not.
Cristina.
Absolutely.
Now, as far as her being in that car, it was your belief the car was running.
Yes, sir.
Would you or Rita ever have left her in that car if y'all thought it was not on?
Never.
No further questions.
Anything further, Mr. Lloyd?
I don't think I asked you this earlier, for clarification's sake. Are you and your caller, Rita, are you and Rita in a relationship now?
No, sir.
Have you been in a relationship since that day?
No, sir.
Thank you. No more questions.
That's listed.
Thank you. First of all, you weren't out with Rita at 12:30 when she walks back out to the car, were you?
No, sir.
In fact, it didn't look like you were on the porch or anything, right?
That's right.
So you know what you did. Correct?
That's correct.
So your opinion about the car being on or off at this point, you don't know one way or the other, do you?
Actually, I don't.
Your testimony is the car was already on.
Yes, sir.
Okay. And you gonna stick with that, or we change it now to Rita
No,
turn
sir.
their car?
Rita did start that car.
What now?
Rita did turn the car on. I didn't turn the car
When did Rita turn the car on?
on.
Oh, I'm sorry. Rita turned the car off. When did she do that?
To be honest, I'm not sure, sir, when she started the car.
You didn't go out here after this point, so you don't know if the car's on at this point or not, one way or the other, right?
I don't.
All right, let me go to exactly 12:30:25, please. And is it fair to say, sir, that if she's turning the car on now, the child has still been in the car for at this point an hour and 15 minutes?
The car was running when I put the child in the car.
Okay.
I don't-
It's already on, right?
I don't know what Rita's doing right now. I wasn't outside.
Right.
Is it fair to say she's opening both doors at the same time? Go back to that again, please, sir. Fair to say she's opening the front door?
Yes, sir. Yes, sir.
All right, this is the first time I'm talking about this. Okay, it's 12:30. She walks back to the car. Is it fair to say she's opening the front door?
Yes,
And
sir.
the back door at the same time?
Yes, sir.
Wondering why you would do that unless you were airing out the car.
You know,
I don't have any further questions.
I'd ask for a strike. Solicitor's last
I'm
comment.
sorry, I should have put that in a formal question. Can you come up with an idea why somebody would open both doors at the same time unless they were trying to air the car out?
Calls for speculation, Your
I
Honor.
don't
I'm
know.
asking.
I don't know,
I'm
sir.
You don't?
objecting that it calls for speculation. I'd ask for a strike.
Objections overruled.
Thank you.
Anything further, Mr. Phillips?
Just one question. When you watch that video, we can pull it up again because this is mainly for the jury. And go back to, I guess their main contention is the fact that two doors open. When you watch this video, and because there's really two interactions, her sitting down in the driver's seat for a period of time, and then the second one where she goes back to the car and opens both doors, she peeks her head in and looks at the gauge of the car, specifically looks at the front part of at what I assume would be the gauges of the car.
Yes, sir.
All right? She says something, and then she sticks her head in the car. That's what you see.
Yes, sir.
It's not that she just opens two doors.
Yes, sir.
Thank you.
Anything further?
No, Your Honor, thank you.
No, sir.
You may step down.
Yes, sir.
Call your next witness.
Your Honor, defense rest.
Further defense, King's case. Mr. Phillips, you may proceed.
Thank you, Your Honor. Ms. Pangalangan will call Robert Erebus.
Mr. Erebus.
State your name again for the record.
Robert Erebus.
Spell your last name.
Arabis.
Mr. Erebus,
Yes, sir.
if you could, please introduce yourself to the jury.
Hi, my name's Robert Erebus.
And where do you work?
I work at Stokes Lock. I'm the owner of Stokes Lock and Key.
And how long have you owned and operated that business?
I've worked there for 38 years, and I've owned it for 36 years.
And I would say through your training experience for that many years, you know everything about unlocking vehicles.
Not everything, but a good bit, yes.
You would consider yourself well-versed in unlocking not just homes and different locks, but vehicles.
Yes, sir.
How many vehicles do you think you've been called to help unlock?
I thought about that the other day. Thousands, like 2,000 or 3,000.
And I notice when I come into town, I see Stokes Lock and Key. So, I mean, you're a staple here, right, local in the community. Is that
Yes,
fair
sir.
to say? And with serving the community, total in your 36 years, again, do people call you to ask you for help randomly as well? Kind of?
Sometimes like advice help.
Yes, exactly.
Yes.
And on August 5th of 2019, did you get a phone call
Yes.
related to this case?
Yes.
If you could, explain to the jury what happened.
I got a phone call from a person that I knew named Larry King. He sounded very frustrated and told me that he was trying to get into a car. And I don't remember if at that time it was mentioned that there was a child in the car. And I said, well, where are the keys? Are they locked in the car? And he said, no, I have it, but this isn't like a normal key. So he probably told me the year, make, model. I punched it in the computer to make sure I knew exactly what I was working with over the phone. And I realized it was a push-to-start vehicle, and that inside what I call a transmitter, it's not really a key, there is an emergency key hidden in there. Sometimes you press a little button with your fingernail or a pen, or you slide something, depending on the year, make, and model, and you pull this emergency key out. Now, it usually goes only into the driver's door lock, but sometimes that driver's door lock is not visible. It's where the handle would be, and there's a cover where your cylinder would normally be, and that cover has to, you actually take the blade of the key and come underneath it and pop that little cover off and then stick the key in, and that's how you unlock the door.
And you explained that process to him.
Well, again, he sounded very frustrated, and I could hear him like, how do I describe this? Like trying to, I don't know if he was kicking the car or if he had been working with a coat hanger or something like that, but he was very frustrated and said, you don't understand, this car doesn't take a key. And I said, no, I do understand. And he mentioned something about somebody going to get the other transmitter. And I said, that's not necessary. The transmitter you have, do this. So once he got the key out, I told him, although there's no keyhole on the driver's door handle, you've got to come up underneath, pry the cap off that conceals it. It must have been a higher end vehicle, and then just turn the key. So we're doing all this, and it's happening pretty rapidly. And let me get...
The best of your ability, take your time.
So, after the conversation with him, I never really heard another voice. And I hear voices when I'm talking to other people, hear voices as in they're in the background. And he had to have gotten in the car. I probably even described like, pick up a brick and throw it through the window. But again, he didn't sound like the Larry King that I knew. This is something different. He was very frustrated. And I heard they obviously got in the car, and there was obviously a female there, because I heard, and this is how the phone call pretty much ended, I heard a female say, overheard a female say, continue?
You're not supposed to. But if they're not going to object. I think that's hearsay.
So don't...
He's objected. It's
Okay,
fine.
so after then the phone made a sound as if it was dropped, and I heard just sounds in the background, including, well, I can't, you're saying I can't say that.
But based on what you heard, what did you do then? Because I think at that point
The phone went clickety-click, like as if it had landed somewhere, and then the phone call got disconnected.
And at that point, you believed there was definitely an emergency involved, based on what you heard.
I knew there was an emergency involved because of, well, I'm not being allowed to say what I overheard on the conversation. So I said to a friend customer, who's a friend of mine outside of business, and another customer, because I'm right there on Jeffries. You're about to see more fire trucks, ambulances, police cars than you've ever seen in your life come flying by here at maybe 90 miles an hour, any moment now. And I would say within 4 or 5 minutes of that, every fire truck, EMS, police car, and weren't even doing 70, they were doing more like 90. This is 35 out there, you know when somebody's speeding. And I said that again to this friend, and he's a customer, and they asked me what happened, and I told them pretty much everything here, because one of them knew Larry.
You knew something shocking had happened at that point.
Oh, I was certain, because of what?
I understand.
Yes, sir.
No further questions, Your Honor.
I don't have any questions.
None. Thank you for coming.
All right, thank you, sir.
Thank you.
Next witness.
Almost, we'll go past noon. 10 minutes.
Next witness.
All right. Your Honor, defense calls Nancy Close.
Okay, Nancy,
Carter.
all right.
Nancy Benton Carter, and my last name is spelled C-A-R-T-E-R.
Hey, Ms. Carter.
Hello.
If you could, give a little background about yourself and then how you know Ms. Pangalangan.
Okay, I'm a retired educator. I've spent all of my years in Colleton County. I started in 1976 as a classroom teacher, and then I became an administrator. And in 1987, I became principal of Blackstreet Elementary School. And during that time, Ms. Pangalangan became a student teacher. And then I was able to hire her as a classroom teacher, and she was a first grade teacher. So all my experience has been in education.
And how long did you teach with Rita?
Her student teaching was the years 92 or 93, and we were together 3 years at Blackstreet. And then when they built Northside Elementary, I was transferred there as the principal. And then about half of the teachers at Blackstreet were transferred to Northside with me, and then some other teachers came. So we were together there 5 years. So together, about 8 years, we were co-workers.
And so not only as co-workers, would you describe yourself as friends?
Not personal friends, but professional friends.
As far as work and how she interacted day to day?
Correct.
Right. And how would you describe her as a co-worker?
One word that comes to mind is passionate. She was very, very passionate about what she was doing. She was an excellent first grade teacher. You knew that she loved what she was doing. That was obvious. It was one of those teachers which sometimes you had to wonder when the door was closed if they were continuing their job. That's not anything I had to worry about in her particular situation. She was always doing what she needed to be doing. I would consider her reliable, dependable, helpful. There were times when if other teachers needed help or if I needed additional help, she would definitely jump in and help. One situation comes to mind in which I had a kindergarten teacher who could not always show up for bus duty on time in the morning. And so Ms. Pangalangan would go down every morning and check to see if the teacher was there, and if the teacher wasn't there, then she would take her place until the teacher arrived. And then there was another situation about being helpful in which the school district required that we keep track of all our professional development and any kind of activities like that that we had. And so at a faculty meeting at the end of the year, we were talking about that, and I had a teacher raise her hand, and she did not have some of the information she needed. Well, Ms. Pangalangan had everything written in detail, so everybody started writing down the details then. So everybody was appreciative of her helpfulness then.
Let me stop you.
Okay.
You knew Cristina, right? You knew how she had sometimes brought her to work. You had seen her interact.
Cristina was born after I left Northside.
But you stayed in contact.
We would run across each other every now and again, but my contact with Ms. Pangalangan and Cristina actually appeared on Facebook. I would keep up with the things they were doing on Facebook, so I kept up with Christina's life and Ms. Pangalangan's life on Facebook.
And you ended up going, I think, you did some retirement work at the board, is that right? And
I officially, or technically retired in 2005. And then I went back to the school district and worked part-time until 2013. I think that was when I turned 62, and then I decided that was it.
And with that, y'all had stayed in touch randomly. Y'all had conversations between then, enough so that when all this happened and she was arrested, you visited her right after she was arrested.
Yes, I did.
And you describe her as remorseful?
Yes. She was very upset.
Genuine?
It appeared that way.
But you felt so compelled in knowing her that you still, after all that time, wanted to go visit her to see how she was doing.
Yes.
And you're here on her behalf, not to talk about anything that the specific allegations, but to talk about her character.
Correct.
And you would describe her character specifically, I don't want to put words in your mouth, how would you describe her character?
I feel like she's very caring. When she was a classroom teacher with her children, she worked with them. She had children who were above average, average, below average, didn't matter. She was able to work with them. Discipline problems, she was able to take care of those. If somebody went over the top, she would bring them to the office for assistance from one of the administrators. But from my recollection, that did not happen very often.
Is there anything else from a character standpoint or who she was, as far as you know her, else that you would like to tell the jury about her?
Miss Pangalangan, when we worked together, she was a very caring person, a very honest person, and it was somebody that I could count on. whenever I needed anything.
Thank you. No further questions.
By the state.
Yes. Ms. Carter, just a few questions. So this was how you would describe her when you worked with her, is that right?
Yes.
And I'm trying to get my time frame, so please correct me if I'm wrong.
Okay.
You guys actually stopped working together in what year?
2001.
2001?
I left Northside, yes.
Yes, ma'am, 2001. And then after that, Facebook, but no direct contact, that type of thing, is that right?
We would maybe see each other occasionally somewhere, but not as far as co-working.
Okay, so the co-working and the stuff that you're talking about occurred basically 18 years before this happened?
Correct.
2001?
Correct.
Okay, thank you, ma'am. As far as your relationship, then even in that time frame, you were professional friends and not personal friends, is that right?
Correct.
You didn't, I'm assuming you didn't socialize very much, go out with her or anything like that?
No.
You never went on, any kind of date? Were you around her when she was with Larry?
No.
Okay. Were you ever with her when she was doing meth?
No.
Did you know she did meth?
No.
No further questions.
Nothing, Your Honor. Thank you.
Mr. Phillips.
Even beyond your retirement, she was a math coach.
You also oversaw that as well?
I would run across her occasionally, but her supervisor was the principal at that particular school.
Right. But she wasn't a stranger to you. You and I spoke. You certainly made it clear
Yes,
that...
she was not a stranger to me.
And you said you had kept up with her, and you felt so compelled by the relationship y'all had, you went and saw her right after all this.
Yes. I don't remember whether I said this earlier, but Cristina was not one of her children that I knew. However, with Facebook, I kept up with Cristina and Ms. Pangalangan's relationship on Facebook because she would post pictures of Cristina in her house, or Cristina especially swimming, and they were just cute pictures of their relationship.
And how would you describe that relationship through the pictures? I mean, as you just said.
It appeared to be a very caring relationship.
All different kinds, taking her to Special Olympics.
I think I do remember pictures of Special Olympics, yes.
In different places.
Yes.
And stuff that they both loved to do together.
Yes. Especially the swimming. Those were just very cute.
Thank you, Your Honor.
Anything further?
No, sir. No, ma'am.
Thank you. You
All
may
right.
step down.
Thank you.
Clock says 11:59. That means we're going to stop for the day. And we're going to want to start back at 9 a.m. on Friday morning. Hopefully everything will be fine and we can get here at 9 a.m. Is there anyone who cannot be here at 9 a.m. on Friday morning? And from Jackson, is it Jackson Borough? All right. Tell me what's in your requested charges.
One specific would be, under the Watson case, essentially that
He's charged a combination, firmly convinced and hesitation to act. Yes, sir.
And give me 2 seconds, I'll get it pulled up. Some of them that I have are included are general ones that are probably already included in your standard charges. Always make sure to have them available. 1 second.
Mr. Stone, I know that you have not seen the wording of Mr. Phillips's requested charge, but is there a conflict in what he just said with?
You know, I don't think there is. I was kind of going through that in my head. I think, in fact, it could probably be just added to the state's request to charge or put in there as well. I think it's the same thing. It's very interesting, but I think basically what he's saying is the only change in language is the additional word of extreme recklessness.
He loves
is that
the word
right?
extreme.
And I think that's consistent with the request that I made.
So the specific language I have listed is malice and recklessness are not equivalent. Extreme recklessness can lead to an inference of malice. And then giving the state what's the citation from who's on it. Malice may be inferred from an act so reckless as to manifest the depravity of mind and disregard of human life. I think that's marries with both, and that's exactly the way the law is listed in Locksmith.
All right. So you all will look at each other's and
Yes, sir.
tweaks, comments, whatever, and then we'll decide
Yes, Your Honor.
in the end.
Of course, the Logan circumstantial evidence charge,
Yes, sir.
mere suspicion is not enough to sustain a conviction, that language.
Yes, sir. And you have all this written out in the requested charge.
Yes, Your Honor. I'll email that to you in just a second. Of course, the other standard is not for innocence, all the other standards. And the only other matter that I have is as to state's request to charge 2, there hasn't been a defense presented, and obviously unless something happens that I'm not aware of, the state has requested a charge for voluntary intoxication or use of drugs does not constitute a defense to a crime. That has not been presented by the defense, and so this request at this point, we believe, one, is not proper, because there hasn't been any evidence presented. The standard for a jury instruction is any evidence, and there has been any evidence that voluntary intoxication is a defense.
Yes, sir.
There certainly has been testimony of voluntary intoxication, and I want to make sure, especially when we're talking about extreme recklessness and the other standards of the mental state, which is really what this whole case is about, that there's no confusion with the jury that, they were hyped up on meth, so that's an excuse. That's why I offer it, because I know the state of mind is the crucial linchpin to this case, and there's clearly been testimony about voluntary intoxication. In fact, that's why I actually used the one that said voluntary intoxication and the use of drugs. That's the reason that's in there. So I think it is relevant. I do think it's important in this matter.
Roy?
If I could inquire, is Your Honor's standard charge include a mere presence charge that this person is
Yeah.
not guilty of the crime merely by being present?
Yeah, and there is a mere presence charge that's
I'm requesting
generally
that.
not, it will be charged.
Thank you.
Must be participating, basically.
Thank you, Your Honor.
So this, whether you call it a defense or not, but the defense's acknowledgement, mistakes were made, she'll have to pay a price, but it's not murder.
That's right.
So is that a defense when you say to the jury, well, we made some mistakes, we're not totally innocent, we are guilty, but we're not guilty of murder?
Voluntary intoxication is very specific. His charge of voluntary intoxication and use of drugs does not constitute a defense of the crime. We have not presented a defense of voluntary intoxication. Without there being any evidence of a defense of voluntary intoxication, this charge is improper.
Well, there is evidence of voluntary intoxication.
A defense of voluntary intoxication. I've objected to every bit of the testimony in toxicology related to intoxication. That's been a thread throughout this whole trial.
Well, you've objected, but King has introduced evidence up to this point saying, well, I used crack all night, I hadn't slept for 3 days, not crack, but meth.
But they haven't raised the defense of
All right.
voluntary intoxication.
So the question is whether or not something has to be raised as a defense in order for the court to charge it.
That would be one thing, because if you're
Well, that's the question.
that's what
And both sides have to weigh in on that question.
my position is.
Of course, the court can charge anything that's raised based on the evidence, whether it's requested or not. Go ahead.
My position is that we absolutely have to raise that defense for it to be in.
Yeah, and I'm saying, give me some authority for your position, that it absolutely has to be raised as a defense.
And there's certainly, unless there's some, I don't believe there's any authority saying that I'm wrong.
Well, that's the question for you all to muse on and think about.
And I think the case that actually handed up is actually it's a question that was raised at the appellate level, and concerning whether or not they could have. I don't, and I think it might have even been a part of a PCR. I'll research it, but I don't. Anyway.
Yeah, of course, we always overemphasize what a jury charge versus argument,
Yes.
and jurors get back and decide the case based on the.
Of course, under
view
that
of the
theory,
facts.
though, also, the state hasn't raised the accusation of mere presence either, but I acknowledge that needs to be charged to the jury. There's a lot of stuff that we don't necessarily raise as either part of the state's case in chief or the defense, and yet there's still a law that needs to be charged to the jury to clarify any issues. So I still think because of the particular nature of this case and the mindset of these two defendants and an abundance at this point of testimony concerning voluntary intoxication and the use of drugs, I think it's the appropriate charge.
Yes, sir.
And specifically, if your Honor's position.
I have no position. I'm posing questions.
All right, well, we'll get.
I'll have one when I make the decision.
Perfect. And if eventually, if your Honor rules that the co-defendant, his testimony triggered this specific charge, that he presented that evidence, then we have potentially a direct conflict between the rights of one defendant and another, and I, at the appropriate time, just to give you a heads up, would move for a mistrial,
Yeah.
and that it would have been a severance.
We haven't. We're talking possible jury charges. You haven't finished your case yet.
That's true.
You know, we haven't heard from your client yet. You indicate she's going to testify. I don't know what she's going to say.
That's fair.
Right. Okay. All right. Well, we have a day and a half almost to
Yes, sir.
before being concerned about that. Maybe 2 days.
With what I'm understanding is the storm surge at my house, I'm not sure I have a day and a half, but I appreciate the optimism. I hope I have a day and a half.
Okay. Well, hopefully everyone will be safe and we can reconvene at 9 a.m.
Thank you, Your Honor.
safely.
Thank you.
All right. Thank you all.
Take care. Thank you.